They have got better, very good skills in conflict management, in consensus building, which I believe is very crucial in the office we are seeking today.
Maybe Your Honor, you can fast forward now to your position as a judge.
Yes. To fast track that, I quickly joined after 1 year, I joined the East Africa community. That is important. Madam Chair, where I served for 5 years and honed my diplomatic skills, consensus building. And actually at the time I was appointed judge in the year 2012, I was in Brussels negotiating the economic partnerships with the European Union. That's when I received the news that I had been appointed judge. And I was actually not able to come for the swearing in because we were in these critical moments of negotiating the partnership with the European Union. So I came 3 months later after the judges of Employment and Labor Court had been sworn in July. I was able to come in October. They had been asked to elect their principal judge by Justice Mutunga, and they refused. They said they would not do so until I come back. They knew me because I had led them at the university. I didn't know them personally, but that is what they did. Actually, I remember Justice Kihara, commissioner here, had to be sent to them by the Chief Justice. And they told him also that they would wait for me to come back. And as soon as I came back, I was elected the principal judge of the Employment and Labor Court, which I guided very well from the Labor Ministry. It was a small court in the Labor Ministry. We had no offices, we had no furniture, we had no books, we had no seat in the judiciary. So I transitioned the Employment and Labor Court from the Ministry of Labor to the judiciary, and it was a formidable task. And we set up the systems and got the Employment and Labor Court to where it is today, including developing the rules, the charter, and getting the staff, because we didn't have any staff. All the staff in the Ministry of Labor, so it was a mammoth task, and doing the assistance of the Chief Justice and CRJ, then we were able to achieve that, and even roll out the court to the stations in the various counties and establish up to 9 sub-registries. So those are the skills which have continued to hone today, which I believe make me suitable to serve the people of Kenya in the position of the Chief Justice.
Thank you, Your Honor. In an article appearing yesterday in the Study Nation by Gitau Warigi, and I quote, Your Honor, "The country needs a CJ with a vision, good temperament, and intellectual heft." So please explain to us, Your Honor, this statement by explaining your vision very briefly, also commenting on your temperament, and also commenting on the intellectual heft. Just briefly, Your Honor.
My vision for the judiciary of Kenya is to upscale and consolidate the gains so far in the access to to justice and delivery of justice to the people of Kenya in an expeditious, fair, accountable manner, because that's the bottom line. All the other initiatives to do it are just enablers of that overriding objective to deliver justice to the people of Kenya in an expeditious, fair, equitable, inclusive manner, and in a friendly way, so that they feel wanted, because justice, the administration of justice derives from the people, and our obligation in the judiciary is to serve the people. And so as a Chief Justice, I want to have a blueprint consolidating judiciary transformation. And its key elements derive from both JTF and CJT, because all we are doing is to upscale this, access to justice especially, and clearance of backlog, accelerate productivity of the judiciary staff, build confidence from court users, so that together we can have enhance the rule of law in this country. We can enhance equity and equality in this country. So that so what do I do as a leader? With my blueprint, I will engage everyone to develop it. I believe in delegation and direct leadership. I believe in participatory initiatives, and then delegating to the teams. I believe in the teams I work with, and I have looked at I would work within the framework of the 2019-2023 strategic plan. I'm more concerned about the 2017-2022 ICT master plan, because I believe what will unlock the potential of this country is streamlining and escalating the automation of the codes, the e-filing system, the case tracking systems, the case management systems, basically the monitoring and evaluation systems. That is what will take this judiciary to the next level, and that is what will get the judiciary to productivity levels which will be make a big difference to the people of Kenya.
Okay, Your Honor, what about your temperament, just briefly, because those details will come later.
I am very easy to work with. I am very amiable. I found myself everywhere I've been easy, very easy and comfortable with people. I've not had difficulties in my court proceedings many a times. In all those years, I have been a judge. And I believe I have built a lot of friendships across the judiciary and in the country at large, largely due to that emotional capacity I have to be in charge and in control of my emotions.
Okay, thank you very much, Your Honor. I will now request the Honorable DCJ to continue the questions.
My Lord, Please tell us what you understand by the term organizational leadership. Give us 4 strategic goals you would use to achieve organizational leadership and how you would implement the same.
I believe there are different styles of leadership and leading an organization. But the one I espouse most is leadership by objectives. Establishing a strategy, selling your strategy to the people, developing it into short-term, medium-term, and long-term work plans, developing smart objectives and deliverables, selling those, and then delegating generally to your teams to develop the work plans, providing also for the how those plans and objectives would be funded, and what capacity of personnel you need to implement your strategy in the short term, in the medium term, in the long term. That is the way I believe in dealing with leadership.
My Lord would not work alone and would not expect to succeed working alone. What teams would my Lord put together to assist in the optimum discharge of the judicial function and of the administrative function as Chief Justice?
First and foremost, I believe we need capacity in the office of the Chief Justice, first of all, because I've looked at the organogram, which is the strategic plan, and I've been wondering why there is nobody who works with the Chief Justice. I was told that the Chief Justice comes with his people and they are on short-term contracts and they come and go with the Chief Justice. My proposal, and having worked in the East Africa community with the Secretary General, is first of all to have a few key officials in the office of the Chief Justice to enable him to enable myself with my strategy. First of all, as the leader of the third arm of government, it is very, very important where we are to be able to unlock the matters which hinder us today. And I'm proposing, first of all, that I would, if it's possible, to have a principal liaison officer on a permanent basis in the office of the Chief Justice. He will be serving under the Chief of Staff to unlock the diplomatic initiatives in that office, the consensus initiatives. I would also want to work with a principal resource mobilization officer to assist me in unlocking the financial crisis which we find ourselves, which hampers our programs. So, and with that, I would also want to have a principal legal officer, a tripartite working in that office on a permanent basis, really, in addition to the other hand hoc officers. That was my experience with the East Africa community, and that's why they are funded 50% by the partner states. And we have to fund that organization through development partners, through that office, sitting in in the office of the Secretary General to mobilize funds. And I think that, to me, that model would work very well for me. The key team in the judiciary also is the judges themselves, the magistrates themselves. You cannot achieve anything in the judiciary without them. They are my colleagues, my peers. I'll be only first among equals. One of my...
Yes, my Lord, in fact, thank you for flowing into that area, because that's my second area of concern. So what have you identified from there? What is first the purpose of those employee satisfaction surveys? And what are you bringing in here, my Lord, as CJ, to right the situation from where it is?
First of all, I must appreciate that the satisfaction levels of staff and the court users are very high, contrary to the general perception out there. Actually, I was surprised looking at the percentages in every area. It looks like in almost 99% of them, really, that is where there is dissatisfaction. And that is the core of every initiative that the Chief Justice should embark on to unlock the potential of the judiciary, unleash it, so that we can increase the capacity of the judiciary to deal with the backlog. 2 years, 3 years, 4 years is bad for some dispensation of justice. And so the initiatives which are in the strategic plan include and the key enabler, in my own view, is the master plan, the ICT master plan.
My Lord, there are two issues here. There is the employee satisfaction, then there is the customer.
I was coming back now to the staff.
Okay.
With regard to the staff, and especially the magistracy, and judges also identified two key areas of dissatisfaction: the promotion procedure and career progression procedure. The levels of dissatisfaction with that, in my view, especially the promotion, appeared to be very low, and I believe I would want to engage that area and have a document developed in a transparent manner to be implemented to completely deal with the promotion and career progression of staff, judicial staff in the judiciary. The other area I identified is the disciplinary dispute resolution procedure, which actually is not even an indicator in that survey. Such an important issue, it was left out completely. Yet, this is a cause of staff suing their employer, judicial officers suing their employer, judges suing their employer, because they are not, and we don't have a framework of dispute resolution. We don't have a framework of sorting out dissatisfaction within the judiciary. We don't have the procedure of disciplining especially the magistrates and other judicial is not transparent, is not known. And if it is there, I must say it is not known. And that is the cause of so much dissatisfaction. I would want to address that as a matter of urgency.
My Lord, the magistracy include the Kadhi.
Yes, they do include the Kadhi.
There was some discussion pre-2010 constitution about the Kadhi's court. Please tell us what that was, and today tell us the structural scheme we have in the judiciary about the Kadhi's court, the challenges they face, and whether truly they are part of the judiciary.
I must admit that I'm not very vast in that area, but I will say this, that I know for sure that the process of recruitment of a Kathy is not well streamlined in the judiciary. And there's dissatisfaction in that area, in the manner the chief Kathy is appointed. There was also discussion on how far the special needs of the Muslim community, and especially those dealt with within the judicial system, will be catered for without violating their rights as a Muslim community in Kenya and in the world at large. I believe those are the concerns which Kenyans continue to engage in, so that Kadhis, who are equal partners, equal citizens, equal Kenyans, I mean the Muslim community, are treated equally, fairly, in the way, in every aspect.
My Lord, as Chief Justice, that would be your concern to settle, as would the Court Users Committee functions and their performance, because my Lord would, of course, be the chair, the National Council on the Administration of Justice. Please tell us what the impact of CUCs has been to date, and how their performance is to honestly be assessed.
I noted that also as an area of dissatisfaction in the survey, that especially awareness. There's a big issue of awareness by the people of Kenya as to the existence of CUC.
What are CUCs?
I thought we are talking about the Court Users Committees.
That's right. I'm saying you explain to us what those CUCs are, and under your leadership as both Chief Justice and Chair, how you would make them perform. Of course, you would answer that question with telling us what they are doing right now and how we would be able to assess their performance in improving access to justice.
Thank you very much. As the Principal Judge of Employment and Labor Court, I started the Court Users Committee for that court. I was also able to start the Court Users Committee for the Labor Court, in Kisumu, not to activate it because it was dormant when I went there. And so I have a very good understanding of how the judiciary should interact with its key stakeholders to resolve especially the areas of dissatisfaction. And that is usually the CUC's regular meetings with all the spectrum of stakeholders to where they give feedback to the judiciary, and judiciary answers their concerns, and we work out sometimes training programs, and together we agree on ways of resolving the problematic areas, especially the interfaces between the judiciary and the court users, which are problematic, especially the access to the registry, the facilities they use, accessible to them in the judiciary, taking care of the needs of the people with disabilities, dealing with issues of rudeness, issues of bribery, if they arise, and corruption. And so these satisfaction by the Kenyans will improve by the day as we enhance the capacity of the CUCs to deal with emerging issues. And when we do, because I believe we have been doing it, but also we don't talk very much about what we are doing. And that is why I saw in the survey that a lot of stakeholders were unaware that they in fact do exist. We had, for example, the marches during the Mutunga time. We had we have open days as models of engagement mooted out by CUC. In fact, Madam Commissioner, when I was at the ELRC, I started the first Inns of Court in Nairobi, which is still working today between the bar and the bench. And I had several engagements through the Inns of Court, which I started as a principal judge and which has been taken up by the current leadership, and it continues.
All right. My Lord, please tell us, as Chief Justice, my Lord would wear very many hats, at the minimum 5. Which of those does my Lord consider to be the most important, if that's possible? And how does my Lord hope to better the judiciary by the importance of that role?
The Chief Justice is the embodiment of the leadership and the institution of the judiciary. He is the face of the judiciary to the Kenyans who gave that authority unto us. So the Chief Justice as the leader of the judiciary, and the way he handles his internal affairs and external interactions with key stakeholders is the most important function of the Chief Justice, because those interactions will determine the internal satisfaction with his teams and the external satisfaction with out there, and to a large extent determine whether we are able to mobilize funds to achieve our objectives. We are able to get, for example, the issue of 41 judges unlocked. That role of the Chief Justice, the ability to build consensus as a leader and the embodiment of this institution is key and paramount. And you need a person who can be able to do that in a most judicious manner and amiable, diplomatic manner, yet decisive and honorable.
My Lord has sat in the Employment and Labor Relations Court since 2012?
Yes, my Lord.
As my Lord developed a particular type of judicial philosophy from my Lord's tenure at the court? If the answer is yes, how does that impact on my Lord as Chief Justice, particularly on employer-employee relations?
Madam Commissioner, I would not say that I have developed a particular philosophy other than what has been and a philosophy in me in every place I have worked, to administer justice in a fair, equitable manner, to treat people with courtesy, humility, and to make judgments which reflect the values, principles, and purpose espoused in our Constitution. Indeed, Madam Commissioner, the index of our Constitution guide us in the way we interpret our law, in the way we implement our laws. Those are commands which we must have in mind all the time. And so, I just espouse the constitutional dictates, the principles developed over the years by the nations and the ILO, which have been adopted in this country as guides of what we call decent work and gender and human rights infused employment. Those are dear to me, and their values which are neutral and not biased in any way.
All right, thank you, my lord. Now, is there a disconnect between the law and society? In case your answer is yes, how does my lord as Chief Justice and leading an able team of judges and magistrates intend to reconnect law and society?
In fact, this builds on from where we were with the interfaces between the judiciary and the court users, because the court users are the embodiment of the society out there. So that is going on and is going to be escalated, and the communication channels, especially how we communicate the good things we do, because there's so many good things we do as a judiciary since JTF and SJT, I believe. And under the guidance of these commissioners too, there are very good things which you do. How well we communicate this will be part of my communication strategy to the people of Kenya. There is the issue of education and training within and without. And there must be also interaction in those trainings. We should also have joint trainings with the people out there, stakeholders. I believe that there's room for that, for training as we engage. I believe there's room for social awareness training of our judges. Social awareness training focuses on the values and the principles and the culture of the people, which of necessity a judge must be aware of as they dispense justice. And it's in that understanding that our decisions will become better and serve the people of Kenya more and more. I believe in that dearly, and I would embrace it fully as a Chief Justice.
Thank you, my lord. As one of the major roles of the Chief Justice, one of the 5 I mentioned earlier, is being president of the Supreme Court and being the jurisprudential head of the entire institution. My lord is aware that there's a difference between criticism and critique. So would my lord first critique the performance of the Supreme Court to date? It's 10 years old. And 2, how would my lord, as president of the court, bring a difference in that court?
I am aware that the Chief Justice, you are also the president of the Supreme Court, and therefore the first among equals in that court. I'm also aware that I have very senior judges in that court, many of whom I have personal interactions with, because as I said, I am very easy with interactions, be they upwards or downwards. So I also I've studied and I do use many of the judgments of the Supreme Court in my decisions. And I know, for example, I can identify some decisions which I think have not stood well in my own. The first one, which has given us a lot of problems at the E&LLC and in the magistracy, is the Law Society decision on WIBA. That decision, my problem is with the effectiveness of the orders often discharged, issued by the Supreme Court. Not only in that case, in Mitubel case, and in Moro Ateto case, very good jurisprudence, but in my own view, that more needed to be done, especially in crafting effective orders, because justice orders are not issued just for the sake of it. Justice is dispensed to sort out problems in society. And therefore, the other day, just before Justice Maraga left, we had concerted efforts for him to explain to us in the ELLC and within the magistrates the meaning of that decision, Supreme Court decision, because it has created a lot of confusion across the board in the handling of WIBA matters.
WIBA. Mm-hmm.
Yes, it's a problem. So those are the issues, and up to now, and that will be, I would want to give that attention as soon as I am Chief Justice.
It is that I am looking for the benefit of all of us.
Yes.
So what are you going, my Lord, to do as the jurisprudential head of the judiciary and of the Court of the Supreme Court in particular? What are you going to do so that WIBA does not happen again, if according to you WIBA is not good jurisprudence, and Muruatetu does not happen again, if according to you Muruatetu is not good jurisprudence? What is the role of my Lord as President?
First of all, I'll clarify about Muruatetu. My concern is not the decision itself, but how far the Court of Appeal went in having resolved very well, dealt with the issue of mandatory the death. I mean, they say mandatory, that declaring death sentence and as not a mandatory sentence. It's how far I thought they should have gone so that to deal with minimum sentences which are as harmful to the people of Kenya, especially in matters sexual offenses, and also there's also the issue which I don't know how it was addressed as to the
so
place.
How would my Lord address it as President of the Court?
We are collegial as judges of the Supreme Court. We sit in caucuses. We meet in colloquiums and we purpose to engage in manners, in areas where we could improve the jurisprudence. And that's my approach, being a very democratic leader, very collegial leader, would be to want to utilize the jurisdiction of the Supreme Court to revisit its own decisions. I know some of those matters will come again because we have decisions being made at the lower level, which will come back again, and so there will be opportunity to revisit some of those issues, coming again through the High Court to the Court of Appeal. So there's that opportunity. And when we get those opportunities, it will be my time to use my collegial engagements, in my view, very good qualities which I have to create consensus within the law, and I also like good dissent, because it is in those decisions where we develop our jurisprudence. So my ability, Madam Commissioner, in building consensus, which I will do with all those judges there, and they are all my friends without exception. In that, I have had workings with them, including you, Madam Chairman, in the JLAC. I've worked with you in morning meetings for a long time. I've worked with each one of those judges. I know them personally.
True.
And I am able to easily deal with them at that level.
Thank you, my Lord. Finally, from this end, that court, once every 5 years, is likely to hear the presidential election petition. Do you know what the court may have done in the last 1 year to improve its preparedness in discussing that major petition that comes once every 5 years? Part one of the question. Part two, what would my Lord say has been the success or lack of it in the manner the court has handled the last 3 presidential election petitions?
I know, as a matter of fact, that we have Supreme Court rules 2020, I believe, which have been developed to better the procedures of the court. And since that is the main mandate of the court, I believe that will aid in handling of. We have the Supreme Court elections rules also, which I believe have been tackled in that process to improve the manner in which the court handles.
Any specific one, my Lord?
Yes.
Any specific one?
Specific?
Any specific rule you are talking about, my Lord?
I believe I have come across the Supreme Court rules 2020, if I'm not wrong, in my readings, and which I suppose is an improvement on the previous rules of the court. And although I have not had an extensive interaction with the specific rules which have been developed, and you would understand why, being how busy we are at the level we serve. So we tend to engage with the Supreme Court matters when they directly affect the issues we are dealing with. But for the purposes of preparing for this interview, I believe I've interacted with new initiatives in that court in development of regulations and rules, which I believe will help in improving the capacity to handle future election petitions. Then coming to the issue of the petitions, I have interacted with 2013. Is it 2013? Rider 1. I've interacted with Rider 2. The 2017 ones, and my issue is that these uncertain polling stations to the tallying centers, to the national center, how that impacts the election and the final decision result. I think these areas of disparity in how the Supreme Court went about those issues in the Mutunga case and in the, I call it the Maraga case, Rider 1, Rider 2, and the values, the principles in the Constitution, how they were applied to the election process, the importance of the polling station as a primary area of universal suffrage, where the people speak, vis-a-vis irregularities which might occur along the way, how we, I believe those are the areas which of disparity in those decisions, and jurisprudence will develop as we move on in those areas, no doubt, Madam Commissioner.
Thank you, my Lord. Thank you, Chair.
Thank you, Honorable Acting CJ. I now request Commissioner Honorable Judge Wasame to continue with the technical questions.
Thank you very much, Prof. Chair. My Lord, my questions will be based on the issues you raised with the Honorable DCJ Acting Chief Justice. And I think also with the Professor. You said you left the country because
yes,
you felt your life was threatened, isn't it?
Partly.
Partly.
Yes.
Simply because you were called to the office of the DCI.
If you knew who Senior Superintendent Mashiri was, if you interacted with the...
There are more of them currently.
If
so
you knew, Commissioner, with what was happening at that time of our history, and having received real threats in the corridors of this justice, this corridors of this court, while discharging my duties as an advocate, as a very young lawyer, by the way, at the age of 28, you would understand where I'm coming from. But more importantly, I left because also an opportunity arose because the Kingdom of Swaziland advertised for positions in this country for us to apply.
So is Chief Justice Nduma a person who is, every time he's intimidated or threatened, is likely to leave the jurisdiction of the country?
Not at all, not at all, Chairman. I'm very courageous. I'm absolutely courageous. To take that role I took in that, at that time of our history, very, very few would have dared do that. I can guarantee you. When I had my wedding, at that time, because at the same time when I married, most of my friends could not even dare attend the wedding. It's only the people I was working with at that time who had the courage to come at St. Paul's Chapel to witness that wedding. That's not a period anyone can take for granted. We know what happened to the people of Kenya at that time.
Okay, my Lord, when you are answering the Honorable DCJ Acting Chief Justice, you said there is uncertainty and disparity in the jurisprudence in terms of the election petitions or decisions rendered by the Supreme Court in Raila 1 and Raila 2. Can you tell us two disparities or uncertainties that is apparent in your view from those two judgments? And I'm just quoting what you said, my Lord.
First of all, Commissioner, the interpretation of Section 83 of the Elections Act and its impact on the election process the use of the term and all, and whether it's conjunctive or disjunctive, and therefore whether one who wants elections to be nullified need to show that there was a violation of law and constitution, and that only suffices to nullify an election. Or they must go ahead and show that those contraventions in the law and the constitution did in fact impact the actual votes. That's an area of disparity in those two decisions. The other area of disparity is the weight, the fact that in the Maraga, in the Raila 2, we had changed our rules, election rules, and introduced peculiar electronic rules in the Elections Act. And therefore, the issue of transmission of votes was very prominent in Raila 2. It was not in Raila 1. And to a large extent, that impacted the way the judges decided those two matters. Those, in my view, are two key areas of disparity.
Okay. The Supreme Court is allowed to depart from its earlier decision. Would CJ Nduma Dairy depart from Maraga 1?
If I became CJ,
Yes. God willing.
God willing, that very heavy responsibility will be thrust upon me. And if I were to state my position right here, I think that will not augur very well for my sitting in those cases. So I do appreciate very much your concern, but I would want to reserve, not to answer that directly. But as judges, we must keep on exploring our own decisions, because the Constitution gave that mandate to us. And therefore, we can change today's decision tomorrow, depending on the circumstances and the facts and understanding of the law, the interpretation of the Morgan case and how it was applied, for example, in Raila 2. I mean, really, they used the understanding of and, the ones used. Those are areas which judges will engage in and fit them.
Okay, which means, my lord, you are not willing to take a position on Maraga 1 and Mutunga.
I think it is not right for any judge to do that.
Okay, fine. In Mutunga 1, in Mutunga case 2013, the Supreme Court used the words burden of proof, standard of proof, and evidential proof interchangeably with respect. What do you understand by those terms? And what do you think is the standard of proof in election matters, especially presidential? And presidential election is unique, my lord, it's not an ordinary election matter.
That is, my lord, very correctly another area of disparity in those two decisions. The standard of proof, whether is it the intermediary one, whether it is on a balance of probability. There is disparity in the way that was handled in the two cases. The way it came out in the Mutunga case was not very, very clear to me. That intermediary test, which was developed in that case, it's not definitive and leaves room for divergent discourse and consideration. And I believe Maraga too did engage extensively on that, and they arrived at a differently crafted test. I do not know whether it is intermediary or it's on a balance of probabilities. But the test in Maraga 2, it's the determining factor was factual. The facts that they stand dictate that we decide that the dictates, the principles in the Constitution were not adhered to. And I think when you deal with us, with the standards of proof described in so many words, has to be on a case-by-case basis to unravel what the true test is. And so that uncertainty persists, in my view, of what standard is applicable in an election petition.
My Lord, we want to get your position, and that's what the Honorable DCJ was asking. What, in your view, should be the standard of proof in presidential petition against ordinary election petitions involving MCS, members of parliament, governors, and senators? What should be the standard of proof in one side and the other side? And now that you are presiding as the Chief Justice Nduma, God willing, 2022.
The standard of proof in civil matters and electoral matters should not differ, in my view, whether at the parliamentary stage or the presidential stage. Strictly speaking, these are civil matters, and the principle, the burden of proof. But with regard, we are very well guided on how to deal with these issues in terms of Section 83 and the relevant provisions in the Constitution. We have the principles which tell us that constitutional edicts which say that this standard of accuracy, transparency must be achieved for an election to be free and fair. And therefore, when you infuse the constitutional edicts into while interpreting Section 83, I think the matter should be very clear. But we always say that the law is very clear. But when we get into the discourse, it becomes not clear. But I believe, in my view, the dictates of the Constitution must prevail all the time, because we give it to ourselves, and we must adhere to those standards which are contained in that Constitution we gave ourselves. The values, the principles, and that is what impacts the manner in which we interpret that we arrive at the standard of proof in that presidential election. And I do not believe that those edicts apply only to presidential elections. They apply across the board. Only that the Supreme Court has expanded its jurisdiction to deal with parliamentary matters, which were supposed to end at the Court of Appeal level. And so there was not going to be an area of disjoint if the Supreme Court had stuck to its jurisdiction given to it expressly in the Constitution. I believe there was a bit of craft in the extension of jurisdiction of the Supreme Court to deal with parliamentary elections.
Why I'm asking, my Lord, and I'm consistent, is that in a presidential petition, the case is decided on affidavits filed by the respective parties. There is no cross-examination. There is no re-examination to trace the veracity and the truthfulness of the evidence proffered by the parties. While in ordinary election petitions, everything is tested through cross-examination. And as a judge doing trial, you will be able to know who is telling the truth. Therefore, is it necessary for us to separate the standard of proof in ordinary election petition from that of presidential petition? That's what the question I'm asking. And I want you to give some highlights.
From where I come from, I hold the view that the principle, the manner in which an election should be conducted at every level, as found, first of all, in the Constitution, and the principles, the procedure that must be followed is a guide as to the standard which of proof that must be applied by the court. If the edicts of the Constitution are mandatory and we are enjoined to implement and enforce all of them, I believe there should be no area of disparity in presidential and parliamentary elections. Only that the statutory provisions guiding the statutory provisions guiding the processes may differ. No, they don't differ, because yes, they do, and the difference in any statutory provision should not impact the edicts of the Constitution, because that is the base. And so, while saying that parliamentary elections ought not to have gone to the Supreme Court in the first place, I believe that the standard of proof should remain universal, as we gave to ourselves in the Constitution.
Okay. You said you have wide experience in labor matters, and you're one of the most experienced judges, as you said, having been presiding judge in this country almost 4 years. You also worked outside the country, so you have a lot of labor knowledge.
4 years, my lord.
As a presiding judge?
5 years.
5 years, okay.
Yes.
5 years. Thank you for the correction. Are you a judge who treats everybody equally and fair?
I have never known otherwise. I do that all the time. And every person is fallible, though. And the thing is, well, as a judge, you exercise your decisional independence, and litigation, unlike mediation or other out-of-court methods of settlement, all the time, and most of the time, is for one person and not the other. And so, people will always express dissatisfaction with the decisions which come from the court, because when they come to court, they have high expectation that the decision will go their way. And therefore, and that is the exact reason why the decisional independence of a judge is paramount. Otherwise, the judiciary will be haunted forever. The judges will be restless. They will be haunted, as is happening, and it is happening right now, haunted by their decisions. Instead of people going on appeal when they're not happy with their decision, they file a complaint. And that is why, and I forgot, when I was being asked questions I didn't forget, I'm very concerned about the vetting process of complaints before they get to the JSC. No, before, and by the JSC, before they graduate to a disciplinary, to a process, an inquest, where a judge is required to come and defend himself. That vetting mechanism, I would want to pay a lot of attention to it, because I believe it has become a big cause of concern to the constituency of judges and magistrates in this country. Because, again, there's no document which tells us the standard of required for a matter to graduate from a committee. Like happened during Mutunga's time, we had the committee chaired by Supreme Court Judge Wanjala. And at that time, being the principle of the Employment and Labor Code, that committee interacted with me continuously when complaints came from my court. So they made me aware of it, and in those interactions, almost all matters which would have otherwise graduated into judges being summoned before the JSC were resolved. And so my suggestion is that the heads of courts, the principal judges, the heads of state divisions, the judges, very senior and honorable, should be involved initially by that JSC committee in the vetting process, and to find out whether the genuineness of these complaints, and whether in fact these are matters which are an attack on the decision or independence of a judge. And I must tell you that once a judge has been summoned to appear before the JSC to answer to charges, the amount of time you take a lot of time out of your work to dedicate yourself to that matter. We hire lawyers all the time to come and defend ourselves, and judges are paying the suffering in that respect. I would want a transparent vetting mechanism, as happened, although it was not documented during the tenure of Justice Wanjala. There is evidence that almost all those matters never arrived to be considered fully by JSC. That is my answer to this question. And that is why we are inundated every day with complaints which ought to be appeals to the next level. How are we supposed to work as judges? Because the time you take out of your schedules to give justice to the people is entirely now dedicated to a matter before JSC. And if you're going to have 10, 20 judges appearing before JSC at any one given time, the psychological trauma the judges go through, I, as a Chief Justice, would want to address that as a matter of urgency in developing a transparent vetting criteria, taking into account that we serve the people, and we are also the people, and we should not be haunted because of the mandate that they have given unto us. And that is my belief, Commissioner. Okay.
My Lord, I request you pay attention to this quote made by a judge. With the greatest respect and at the risk, with the greatest respect and at the risk, unfortunately, of appearing uncharitable to the learned judge, his judgment was somewhat conflated, not least because it was difficult with great circumspection to discern the findings of the court and the reasoning thereof, as opposed to the submission of the counsel and the pleadings in the case. The learned trial judge was enjoined to be dispassionate and was required to be guided by the facts emerging from the evidence in the case and to apply correctly the law to such facts. He was bound to adhere inter alia to the national values and the principles under Article 10 of the Constitution. It was not in the purview of his jurisdiction to engage in speculation or conjecture. much less to show partiality in the dispute. A judge should never take sides or be guided by extraneous matters. A judge is required to be guided by the evidence before him, from which facts emerge to which he or she should properly apply the law. A judge should not be intimidated or be influenced in his decision by statutes, by status, wealth, power, or influence of a party, and a weaker party does not have greater rights by dint of his or her station in life, though the court may be more sympathetic to such party. In a nutshell, litigants are equal in the eyes of the law, and none has greater rights than the other. The Constitution enjoins every judicial officer to be fair and serve justice to all without jurisdiction. Is that a reflection of you?
That is the Cholet matter, which
I didn't say it's the Cholet
that
matter.
is the Cholet matter which I decided.
Yes.
And I remember those very words from one judge who sat in that Court of Appeal panel, which dealt with that decision in the Cholet matter. And the way I understand the role of a Court of Appeal judge, and we have a lot of writings on that. Sorry.
Sorry, excuse me.
My understanding of the role of a Court of Appeal judge, Court of Appeal judge should never ever be involved in that kind of frolic about a judge who handled a matter below him. To me, that was completely out of step. All the other judges in that panel considered that matter in a very considerate way. And I believe, in my view, that particular judge was guilty of the very things he was talking about there. And that is one matter which I still believe ought to have gone to the Supreme Court, so that all those issues are dealt with, so that we know who indeed was partial and who was impartial in that matter. That is my belief.
Okay. Again, one of the other judges also described you like this. I don't know whether you agree. It is clear from the phraseology employed by the learned judge that he took an extremely dim view of the manner in which the appellant dealt with the disciplinary process that led to the removal of the first respondent. The learned judge considered the entire process as fatally flawed and contrary to the law. He saw this as asymptomatic of an enthusiastic and insistent, overzealous, even attempt by the appellant and its chairman in the person of the Honorable Chief Justice to hear the matter and deal with the first respondent in a partial manner, even if it meant breaching the law in the process. With respect to the learned judge, he appears to have floundered in the same marshy bog of erroneous zeal with which he charged the appellant, and that is why the learned judge collapsed and conflated two separate and distinct disciplinary processes and mistakenly used the statutory markers of one of the tests to the other with the inescapable consequence of erroneous conclusion. Is that a reflection of you?
Commissioner, I must first of all say that...
and that's also another judge, it's not one of the judges.
Commissioner, I know you are involved in that matter as a commissioner. And I know it involved the judiciary as a family, and some people had taken diverse views on what happened within our judicial family, and so a lot of emotions were expressed, not just in judicial decisions that were made at my level and the Court of Appeal, which reflect largely what some of the wordings used. But I must say, and I repeat again, this I believe is a decision which should have gone to the Supreme Court, because I believe there was a lot of partisanism in the way the matter was handled. And at judgment. How do you judge your colleague? How do you pontificate against your colleague? We are guided against that all the time in the principles which we espouse as judges and a family of judges. So I disagree with all those sentiments.
You disagree with those sentiments?
Yes.
Okay. In paragraph 125 of your judgment, this is what you said also. It is difficult to understand the shortcut taken by the very eminent papers of the legal profession in a situation where the mandatory procedure that will have been followed speaks so loudly from the express provisions of Section 32 and Regulation 25 of the Judicial Service Act 2011. That's what you said.
Again, I say, Commissioner, you are involved in that decision,
now,
which I criticized. You are involved in it, Commissioner. And again, I say this is a decision which should have gone to the Supreme Court. I do not agree.
You do not agree with your own statement?
I do not. I mean, that was a judicial decision which I believe will stand the test of time in academia. And that is where it belongs, because it was impugned.
Okay.
And I don't have to answer for it, but posterity will, and academia will. And if it ever sees the light of the day, if it had seen the light of the day at the Supreme Court, maybe we'll be talking a different story. So, Commissioner, in a matter where you are involved, I think you should not take so much time on it, because you also have personal views about it.
Okay. I have no personal views, but let me ask you, leave alone the language used by yourself and the judges, and let's come to, and that's why I said we want to test your understanding of the law. And in this case, you equated disciplinary matters to that of a criminal trial. And you used, I think, the law of criminal trial in all its aspects, and that much you overturned. Is that the position?
Completely misunderstood by the Court of Appeal decision. But it's not true. That is not my understanding.
So you don't...
And I'm saying again, you are involved in that matter. You cannot have an objective judgment about what I said there. It's only an independent tribunal, in this case the Supreme Court, which can pass judgment.
So you completely don't agree with the decision of the Court of Appeal? And I will leave it there.
I don't agree with it. I'm bound by it. I don't agree with it. Well, I'm not supposed to agree with it.
I wish you well, my lord.
Thank you, Commissioner.
Just a small clarification, Your Honor. You talk really passionately about judges who appear before JSC, but just also to clarify, there's so many complaints that come to JSC, Your Honor, which we don't escalate to even to the judges, because we find they are merit-based or they are at the discretion of the judge. So I just wanted to put that information to just clarify. There are many that come and we don't escalate, but there are some that we find that the judges need to come and explain. So I don't know what you feel about that.
Thank you, thank you.
Because there are also complainants who really bring genuine complaints, Your Honor. I'm sure you agree that some of the complainants who have come to us have really genuine cases that we must address.
Madam Chair, my concern is what I would want to be done is to have a transparent criteria developed so that there's certainty in that area. And especially we know the place of decision of making independence of a judge in the way that those complaints are handled. And that can only come up in a criteria developed through a consultative process involving the judges themselves. Because believe you me, commissioners, it's taking a lot of effort from the judges' constituency. So much of it, and taking them away from their work when they should be serving the public. Those many having spent so many hours, and most of those matters eventually are dismissed by JSC, the public is suffering. When you take for example, a whole 8 months dealing with a matter, hiring an advocate, and you don't get costs in that process.
Point is noted, Your Honor. I now turn to Honorable Commissioner Judge Majaja to ask his questions.
Thank you, Chair. Good morning, my Lord. Before I deal with your writings, I just want to follow up on what my fellow two commissioners have talked about, particularly two things. You talked about the Weber case and the Muruatetu case. Maybe briefly, just tell us, what do you think is the role of remedies in the whole question of legal transformation, in your view, in terms of the remedies the Supreme Court gives or the High Court or your court gives in terms of achieving the goals of transformation? Maybe you just explain to us briefly.
First of all, remedies coming from court must be clear and effective for purposes of implementation. Two, those remedies must adhere to the edicts of the Constitution to advance those areas which the Constitution zeroed on for the people of Kenya to advance.
Okay, so in Weber case, what was the remedy? Maybe you tell us and the public, what was the remedy given by the Supreme Court?
In the Weber case, the court nullified or upheld the decision of the Court of Appeal, which had nullified the High Court decision, declaring parts of the Weber unconstitutional. And therefore, we got back to the original position where work injury disputes, work injuries should be dealt with by the director, and they should only come to the courts on appeal.
So basically what the Supreme Court, if I understand, was that it was asserting the mode of alternative dispute resolution, isn't it? At the end of the day, it was saying, look, Parliament has created a mode of resolving disputes. This is the mode, and we are upholding it. Am I correct on that?
The remedy came short.
No. That was the issue, really. I'm not talking about the remedy. First, let us understand the issue.
The Supreme Court upheld the view that there was nothing wrong with the compensation within the process in the Weber, and therefore we should all resort to it.
Yes.
There's nothing
so
wrong.
Basically, they were saying there's an alternative process.
Yes.
And that process should be upheld, isn't it?
Absolutely.
So what was, and that you agree is part of the constitutional...
and I agree with that decision fully.
Okay, so what is the problem with the remedy? What was the remedy? The remedy itself?
The remedy was, the issue is that at that particular time, we had many matters pending in court. Hundreds of matters, if not thousands, pending before the magistrate courts and pending before E and LRC, filed at different times and were awaiting conclusion. So there's an issue of now, how do we deal with matters which were dealt with before the promulgation of Weber in 2007? How do we deal with matters which were filed after the promulgation of Weber, but before the act was nullified by the High Court?
Okay.
How do we deal with matters which were filed before the determination of the Court of Appeal?
So basically what you wanted is the court to give a structured approach.
A structured remedy which now would inform the magistracy, which is holding so many matters and dealing with them in different ways. So and that is why we actually, the court, the principal judge in our court, wrote to the Chief Justice and asking him, please give us clarity so that we know what the magistrates should do with these matters which are pending before them, so that we know what we should do with matters, because we are getting different courts dealing with the matters differently because there was no clarity in the judgment.
Okay. Now, don't you think that also it is the responsibility of your court dealing ex cathedra, dealing with matters, because the Supreme Court has said, basically it has said, this is the process. Don't you think now it is the role of your court to say, or to deal with the cases on a case-to-case basis, like you are interpreting the Constitution, say, okay, the Court of Appeal has said, the Supreme Court has said this, therefore, if a matter comes before us, those are now the issues the court should consider and give, so that it is now also your responsibility as a court dealing with these issues to give direction.
And that is exactly what ELNRC is doing. But of course, the different judges coming up with different approaches. The magistrates are at the same time also dealing with matters before them in a different way. So, we've had caucuses with the Law Society because they have been, and the stakeholders are also very frustrated about the way they are being handled by different courts on that matter. Yes. And we are saying that having had initiatives, the Chief Justice with the stakeholders to resolve the issue, and up to now, there is no satisfaction, especially from the court users. Then we have to wait for our individual decisions, which we are making, to go all the way back to the Supreme Court. How long will it take?
Okay.
How long?
And that brings us to the other question. In such circumstances as the Chief Justice, first of all, you are the head of a CUC. There is a problem which now you agree the court may not be able to solve. And on the other hand, you're engaging with stakeholders, FKE, COTU. What is, because I get the feeling sometimes in Kenya, we want to dump everything on the judiciary to resolve. And you as the Chief Justice, what is your role in telling the stakeholders, telling them, look, this is actually a matter for legislative intervention, for example. Go and make the law. The Supreme Court has said we have a problem. So how do you, as the Chief Justice, deal with that particular issue? Because if we say the case reaching the Supreme Court actually means that somebody has to appeal. And you know the people dealing with those kind of cases have no interest. These cases are small, and they have no interest in waiting for 3-4 years. So what is your role as a Chief Justice?
If I'm appointed Chief Justice, I will deal with it, engage with the matter immediately, because I know it is hurting.
Okay.
And I will take a stakeholder approach to try and deal with it and resolve it.
Okay. And Murwatetu case, what was the problem with the relief in that case?
First of all, I know. I mean, when we were in school, I mean, learning law and reading landmark decisions of great judges, there's a role of obiter dicta in great landmark decisions, where it is clear to the court that a decision being made is likely to impact many other situations, such as minimum sentence.
In Murwatetu's case, yes, the ratio was about the death penalty relating to the two people, isn't it?
Yes.
The applicants. But as a court, one of the objectives of the court is to develop jurisprudence.
Yes.
And to give appropriate relief. Appropriate relief. In your view, how does that jurisdiction to grant appropriate relief gel with the duty of the court to develop jurisprudence? When you're confronted with such a matter, how do the two relate?
Commissioner, that is what I was saying in different words, to develop the law. The obligation of the Supreme Court, being the apex court, to seize those opportunities which come so rarely, to then develop the law to deal with the problematic areas.
And so you agree that is actually what this Morotetu did?
But why are we having a problem with the minimum sentences in all critical areas which were not even touched in dicta?
Well, let me put it this way. What did the Supreme Court say in Murwa? Why did it say that the minimum, mandatory minimum sentence, mandatory death sentence is unconstitutional? Why did it say so?
Because it takes away the discretion of a judge.
Based on what provisions of the Constitution?
Based on the first of all, the decisional independence of discretion of a judge to weigh the facts of a case and arrive at an appropriate decision, which discretion is also taken away in every situation where you are faced with a minimum sentence. To me, that was a cardinal issue here.
That was the cardinal issue.
Yes.
So in the sexual offences cases and the sentencing, what is the problem there?
The problem is that the discretion of the judge to deal with facts of each case on their merit.
So you agree that in fact Morotetu's case opened the door for resolution of minimum sentences?
Opened the door, but it was not definitive.
It was not definitive. In what ways? Because you're saying the court has said the court has to have discretion. So are there cases where the court should not have discretion in sentencing, and if so, what is the constitutional basis for that argument?
If indeed then that has been taken up, if that decision opened that path to deal with all similar cases, not necessarily death sentence, then I would say then the criticism may be unfounded.
Thank you. So let us go to the next, your writings. You have brought for us very good cases on the judgments you have delivered. I'll just go through each of them and ask you a few questions. The first case is about it was a three-judge bench about the payment of agency fees for persons who benefit from union services but are not members of the union. Am I correct?
Yes.
And in the West, it's a very contentious issue. They call it right to work.
Yes.
Right to work, and two judges upheld it and one judge dissented. Just a small issue I want to ask you. You used a lot of you made reference both the majority and the minority made reference to jurisprudence from other jurisdictions extensively, and in fact it's a hallmark of your court to refer to jurisprudence from other jurisdictions, international treaties and standards. What would you say about the concept or the doctrine of what I would call constitutional borrowing as it relates to the work of the Supreme Court in terms of jurisprudential development, particularly having regard to what the Supreme Court has stated in the past?
In novel areas where we don't have a local jurisprudence, such as that case we dealt with there. In addition to considering the context of Kenya as a country on a particular set of facts, the court has an obligation to be guided by precedents from jurisdictions all over. And I think they have done that consistently in their in fact, the many decisions of the Supreme Court, which I enjoy reading, very good decisions, and they do extensively quote from many jurisdictions. I think is a good thing to do, when you are dealing with tackling novel areas.
What is the caution that the Supreme Court has expressed, even when you do that? It has always said something. It has always given a caution.
First of all, a judge doing that must be aware of the circumstances and the legal framework in which those foreign decisions were decided. Sometimes we may borrow precedents without understanding the legal framework and the context in which those cases were determined. So we must be careful as we do that to make sure that we are dealing first maybe with similar circumstances, similar statutes, and all that, so that we do not misinterpret the foreign precedents.
The second case you dealt with was one of HIV and AIDS status, discrimination based on HIV and AIDS, and you've actually found that there was discrimination. This was a case of direct discrimination. Can you just tell us an instance where the discrimination would be indirect? Say HIV, a situation that would arise where discrimination would be indirect, or under what circumstances does indirect discrimination arise?
Indirect discrimination in many workplaces occur in disparity in terms and conditions of service in organizations where we have cadre from different racial backgrounds. So that you would in some situations find that a firm which originates from a particular place and therefore has been able to bring cadre staff from that where the company originated from will within its structures quietly remunerate equal staff quietly.
Isn't that that is actually direct discrimination? I'm talking about an issue where you have a neutral, the indirect is you have a neutral policy, but its effect is, so you don't know whether you have a neutral policy saying we shall give, we shall limit medical expenses to 10,000 shillings without being aware that you have people who are on retrovirals, isn't it? So you have an ostensibly neutral, so the effect is indirect. But back on your issue, and it's a case in which you dealt with, isn't it? The issue you have just spoken about.
Yeah.
You dealt with this was the case of Cambridge, we know it.
Yeah.
You dealt with the trial case, and in the High Court you upheld. What did the Court of Appeal tell you? What did they say about your judgment?
I've actually not engaged with it because with that judgment of the Court of Appeal.
Okay.
I've not engaged with it yet.
Okay.
I'm very happy nowadays with the case back we are receiving from the from.
But
the
you
Court
know
of Appeal.
the Court of Appeal dealt with it.
I did not receive case back from from it.
Do you know whether the Supreme Court dealt with your case?
The Cambridge.
Yes.
Oh, I would really love to follow
because
that.
There are very few cases that the Court of Appeal deals with, Supreme Court deals with. So that case, that's actually one of the ones they dealt with, and I'll tell you why.
Yes.
My colleague, Commissioner Warsame, he talked about the way you have. In that particular case, the Court of Appeal said, look, you failed to consider the evidence that Kemri presented. That's what they said.
Yes.
They said you just took the plaintiff's case and never considered the other case, despite the fact that they had filed extensive documents. But maybe I will not pursue that because you have not read what the Court of Appeal and Supreme Court, that's what they said. They said, both of cases said you had failed to consider the both sides equally, which is a serious criticism, but nevertheless one that the court made. That brings me now to that issue. What is the difference between discrimination and differentiation?
Differentiation cases do arise in affirmative action situations where you could be doing the same thing but you're treated differently for lawful reasons. Discrimination is unlawful.
Is unlawful. It's on those prohibited grounds.
It's prohibited.
But this differentiation is discrimination that is justified.
It's justified and lawful.
And lawful.
Yes.
So in that case which you have were trying to mention, and not even that case, you have your company, let's say Kenya Railways, for example. They have engineers, grade X, job group M, earning 200,000 shillings a month. They want to invest in a system that changes the way in which the trains work. And none of the engineers qualify for that particular, they are all engineers. And they discover this gentleman, engineer from Nigeria, who doesn't have a degree, but he has invented a system which resolves that problem. And when they call him, they headhunt him actually, and they tell him, we need you here because we want to invest in this thing. And he tells them, I want you to pay me 800,000 shillings per month. And they bring him and they pay him here. The engineers complain that this is discrimination because we are on the same group, but you're paying him 800,000 because he's a foreigner. Is that discrimination?
Remuneration and terms of condition of service should always be based on a transparent policy.
So
and where that does not happen, it creates, first of all, a lot of discontent and suspicion. So, for starters, whatever differentiation you make, for it to be lawful, it should be open and transparent. Unfortunately, this is often not the case. And that is what brings the sort of cases we deal with, which sometimes may not be justified.
Okay.
Yes.
Again, I would urge you to read what the Court of Appeal said in the case which you decided. The other case is the Sonko case. And just probably explain. All of us know what employment is. And this is an issue that I don't know whether it has excised your mind. I know it came from a Court of the Appeal decision. Sonko is an elected member of parliament, governor. But in terms of jurisdiction, forget about the Court of Appeal decision, is election as a governor an issue of employment?
Yeah, before I answer your question, let me say this. This almost 10 years since 2010, we are faced with that issue of forum shopping, constitutional division, employment and labor, different code users. Some file same case in both. Indeed, as you can see in that, the history of that case was initially filed at the High Court, was transferred back to LRC.
So tell us.
While I was in Kisumu, and by the time I dealt with it, it had been dealt with by 3 different judges for a whole year, and many decisions made, and the judges recusing themselves in the matter, and it was brought to me 2 days before the Senate proceedings by the principal judge exercising his powers, telling me that I know you are able to deal with this matter and deliver a judgment before the Senate proceedings. You can see that ruling. I delivered it in a record day, 1 day, after hearing very extensive submissions. And the issue of jurisdiction had already been determined by a different judge. So it was no longer open to me to entertain it. I'm very conscious of that. And after my decision, the petitioners have moved quietly back to the High Court.
No, so the issue I just wanted you to clarify for me in terms of as a principle, we know what employment means.
Yes.
So is the election of a governor an issue of employment and labor relations in your view?
In my view, elective positions, strictly speaking, are not employment positions.
Okay.
But there was a difference. For example, like in the election of speakers, where before I made that judgment, there were preliminary objections on the jurisdiction of the court to handle.
No, that one.
Just a minute, and that went to the Court of Appeal, and was decided by the Court of Appeal that we had jurisdiction.
Yes.
And that is how I dealt with it now.
No, you were bound by the decision of
the Court of Appeal. So it's
a problem area. It's a problem area. Let me move on to the 1 or 2 final issues before I wind up in my time. You have talked about, God willing, you'll be the Chief Justice, and one of the issues you'll be confronted with is the same issue you are talking about, management of complaints. And probably when you're the Chief Justice, there'll be a new amendment to the Constitution saying that there's an ombudsperson, who will deal now with the complaints, not a parallel process for judges and magistrates dealing with with complaints. And for the public, the issue, unlike for us judges, they have said, in fact, the Judicial Service Commission is not doing enough to discipline judges. How, if that is the thing on your table, how would you deal with it? You will be faced with an ombudsperson appointed by the president. You will be sitting here as the JSC, and you'll be addressing the judges and magistrates. Tell us briefly what you will be telling us that and our judges that we need to deal with.
First of all the judiciary and independent institutions must be free from direction and control from anybody. And that is a constitutional edict we gave to ourselves. 2, all independent institutions must self-regulate and come up with viable self-regulation mechanisms, like we've done throughout the judiciary of ombudsman and other mechanisms up to the JSC level, which we deal with public complaints. I have looked at the satisfaction report, the court user satisfaction report. The satisfaction levels.
No, the question I ask is very clear.
Yes.
You have come in, constitutional amendment has passed, the first person on
has
the door.
passed already.
No, I'm giving you a scenario.
Yes.
Because it is something you have to factor.
Sorry, I didn't get that.
We have no control over that process.
God forbid.
Yes.
Commissioner, let the judge answer the questions, please.
Yes.
I had not gotten the,
Yes.
the fact that it has passed.
No, I was giving you a scenario saying you come into the office. This was my question. You come into the office, you find the constitutional amendment has already passed, and the person knocking on your door is the ombudsperson.
Yes.
So what is, in light of the problems you have identified in the disciplinary process, what will you be telling the JSC and the judges and magistrates? That's what I wanted to know. Because you have to project forward and have a vision to deal with that. Just that's what I wanted.
I'll start from the point that the judiciary authority is delegated to us by the people. What the people decide, for example, in passing a constitutional amendment like that, is a command to us as a judiciary. And if that will see the light of the day, my only obligation as a Chief Justice is to make sure that it is implemented in a most just and fair manner. And that will be my communication. And we will be able to work out the mechanism of dealing with the ombudsman, who I believe will be a member of the JSC, and therefore if he's out there, he's still with us, and we will find a fair way of dealing with both sides.
Okay. Finally, and my final question, you talked about your defense of the Mutugi Bafo. You confirm, in fact, there were acts of torture of your clients, that in fact they were convicted based on that confession, and that finally the state conceded. Just tell us, how has that colored your perception of the work you intend to do as the Chief Justice? Thank you.
First of all, I do not take what Kenyans, the progress we've made by giving this constitution to ourselves in 2010, knowing and having experienced what many people went through in the 80s and 90s, having participated and actually experienced violation of dignity to the extreme of Kenyans, where confessions were extracted in very, very, very difficult environment with the complicit of the office of the Director of Public Prosecutions. We've come a long way. And with that in mind, I would never ever wish that for anyone and for Kenya, that would ever see that happen again to anyone. And that is a note which will give me impetus and focus to uphold justice for all.
Thank you very much, Commissioner Judge Majaja, and just to emphasize that, Honorable Judge, when we ask for the sample writing, we normally are interested to see your skills in writing judgment and not so much the merits and demerits, because that is discretion. I just wanted to let you know that we know we don't get into merits and demerits because that borders on discretion. We normally look at the skills in writing those judgments, and sure, that's what Judge Majaja was looking at. Thank you.
Thank you.
Commissioner Ajero, can you go ahead and ask questions? Oh, yeah.
Now, Honorable Judge, I'll very briefly go again to the issues of jurisprudence. Then we come to, I'll try to match your skills with the job you are seeking. Now, the sample writings that you've been referred to, there's no doubt you write well. And I'd initially intended to ask you about those decisions, but my colleague has done a good job in that. Now, I'm interested in this case of Equia, because it seems to like it was groundbreaking, and there are two key areas, the one of discrimination based on the issue of HIV, and also the wage disparity. Now, just tell me so that I can understand, your reasoning and how you came about the decision. What exactly informed you, particularly on the issue of wage disparity? Because it's a common area amongst employers where you find that two people are being paid differently for the same job, and particularly women suffer more. The gender inequality when it comes into the women are paid, vis-a-vis men. I'm not sure what could have been the influencing factors to you as a judge in coming up with this groundbreaking decision.
First of all, Commissioner, thank you for that question. This area of discrimination, especially against women, is very well written and researched by ILO and these institutions, and they have promulgated conventions, declarations in that area, which guide courts, different nations, to deal with matters of discrimination. During my time, especially that time when I was writing that judgment, I had initiated interactions for training judges of E&LC, and got an ILO to directly train E&LC judges on awareness of discrimination, different sorts of discrimination. I myself, having been a judge president of Labor Court in Swaziland, I had vast experience in that area. It was my desire that all the judges of the court interact with it. Two, I'm very passionate about mothers and girls. It's a period of maternity leave. Employers fight tooth and nail to limit maternity leave to 1 month, and even less. In fact, that we have embraced 3 years of maternity leave in Kenya is a great progress for women in this country.
That you mean 3 months, not 3 years? I'm sure.
3 months, 3 months. So that background I had, Judge,
okay,
as I dealt with that matter.
Now, tell me, as a follow-up to that, how, if you became the President of the Supreme Court, of course now as a Chief Justice, how you'll be able to use the law in ensuring that you're able to anchor, this development of jurisprudence to protect women, especially when it comes to wage disparity. How you'll be able to progress it so that it becomes all-embracing.
As a Chief Justice, all I will do is to implement our Constitution. We have such a great Constitution. Article 2.5, Article 2.6, Article 10, Article 20, Article 159, Article 259. They have commanded us to develop the law using especially international instruments. It's sitting with my colleagues who I believe would have very amiable relationship with. I'm sure, and I regard them with very high esteem. We should be able to do groundbreaking development of the law in areas which impact our children, our mothers, our boy child, especially now, completely under siege, and persons with disability, and deal with all forms of discrimination.
Yeah.
Yes.
Now, the reason I'm asking this, my lord, is you see the nature of our patriarchal society, and you find that, the influences, the way we are brought up as men, sometimes will also influence how we project our decisions. Now, I'm just wondering, as the leader of the institution, if you could just explain very briefly how you would be able to also use your influence so that even as you're making decisions, these prejudiced influences that come from the way we were brought up in society don't project in the way we make the decisions that end up now continuing with these inequalities. How you would take that, because again you accept this decisional independence on the part of judges, but how would you now use your influence positively to
First of all, thank you very much. The Kenyan judiciary has completely embraced training and education, thanks to Chief Justice Mutunga JTN. And the greatest instrument I use as a Chief Justice, in addition to the collegiality, the key to unlocking that is awareness training, social context training. It's a big instrument in transitional nations, in nations in transit from oppression to freedom. I had occasion to interact with the context awareness training a lot while I was in South Africa, where Canadians usually visited to train us in that area. And in particular, I remember very well Chief Justice Catherine Fraser of Alberta, Canada, who is a champion in context awareness training. And the doctrine that judges in their decision making choose values and not precedents. When you're dealing with high caliber judges like we have in the Supreme Court, you persuade them through training, exposing them to the correct, to peers from other jurisdictions, such as Chief Justice, I think Emeritus Catherine Fraser, who was so forceful in their rendition in these areas of law and context awareness training.
Yeah. Now, the other section of our society that has been discriminated against is so much the transgenders. I don't know whether in your career you've been confronted with a situation whereby you've had to deal with a situation, with a case relating to discrimination against the transgenders, either in writing or hearing the case and how you've dealt with it.
I've not dealt with an actual case, but they have, what's the name of this organization? One of the organization in Kenya, human rights organization, has invited me severally in their training programs for LBGT, and I've had occasion to interact with them a lot and to give them to make presentations to them. And our court, the Employment and Labor Court, I think the organization is KELA, is it?
Okay.
Also, we attended many trainings during my time as a principal judge to sensitize us in those areas. Of course, we know what our constitutional position in those areas, and difficult areas as they are because of our constitutional edicts. But these societies evolve, and our constitutional dispensation in that area will definitely one day reckon with it.
Yeah.
But I have seen groundbreaking High Court decisions by some of our eminent judges dealing with the matter. And so I'm aware of it.
Okay. Now, coming to you as an individual, I must say that even when I was also much younger as a lawyer, I heard a lot about you in handling those cases that many other lawyers, we must accept, or are frightened of, of handling them, defending, the likes of George Anyona, and the rest, and it's quite commendable. Now, I don't know if I could ask again. Of course, you touched on it, because I find you a lot of times as a defender of, rights of individuals, which is a good thing, and again, as I say, I commend you for that. I don't know that those experiences have continued to influence your decision-making process, and also, of course, that also influenced your judicial philosophy, generally based on your personal experiences.
Yes, and to a great extent, but I'm also very balanced, given circumstances of the case. And that is why you can see I have a lot of experience in working for employers, local and international. I've served governments very faithfully in the Kingdom of Swaziland, here in Kenya, and at the EAC. I have really participated in developing key instruments for the East Africa community. So I have a sense of balance and of purpose, and to uphold the law in a purposeful manner. And so I have a balance, although I might accept that the context, the social context, is part of a judge's decision-making philosophy, impacts on the philosophy of the judge.
Yeah, that's true.
It's a fact.
Yeah. Now, Honorable Judge, I do not know now, what is your position regarding judicial overreach and judicial activism in development of jurisprudence?
In the context of Kenya after 2010, where we have specific articles in the Constitution, Article 20, Article 259, dictating to us to develop the law and dictating to us the values and principles which are part and parcel of our law, and we must take them into consideration as we interpret our law, and getting constitutional edicts that we must interpret the law to fill in the gaps to the extent that they do not uphold, effect our Bill of Rights. Failing to implement those edicts and dictates is what I would call activists. Because we have an edict to develop the law, and in terms of as guided by the Constitution. So if you as a judge are not guided by those edicts, then that's what I would call activism, but in the negative sense.
Yeah, okay. The reason I'm asking because I've seen very good decisions that you've made, which I agree with, and largely, I see somebody who wants to protect the rights of, individuals. But again, I've also seen a situation whereby I think in arriving at a decision, you didn't consider the bigger picture, or where there was now judicial overreach. Not to criticize you, I'm just saying that when I look at the decision, and this one case particularly that, because of course, even as we, prepare to interview candidates, you have to also do a bit of research to see the decision they've made. There's one decision that troubled me a little, the KNUT case versus the TSC. And in fact, when I look back, I remember that case was it captured the country because there was a strike and kids were affected, they were away and all that. But now, what I noted about that case, if I could just explain for just 1 minute, I noted that there was extensive evidence that was given in court where economists actually came and said that if you give the awards that the teachers were asking at the time, and we respect teachers and we want them to be paid well, of course, but if you give the award that they were asking for, the implication would be so big in the sense that it would affect, our wage bill in the country would end up being 95.3%, right, of our domestic revenue, because it would create a very huge disparity where it would affect also all the other civil servants. That would mean that our taxes would have to be increased. You can imagine 95.3% of the wage, of the consumption just going to wages. Now, you are told that it would also affect the pension liability, which at that time was, I think, 998 billion shillings. That in itself, the government will not even be able to, the country will not be able to afford. In fact, to me, when I was looking at it, it would literally amount to a national security threat in terms of the implications of the decision. Now, but in spite of all the evidence that was submitted by all these economists, by these specialists, you still ignored all that and went ahead and gave 50 to 60% award, notwithstanding all these warnings about what it would have in terms of implication in the entire country. In fact, you're even told there was even no budget for it. It had not been budgeted for. So it would also disrupt the budgeting process. In fact, you are told, before now you can answer, that you are taking over the work of 5 other institutions. You're taking over the work of Salaries and Remuneration Commission, Teacher Service Commission, Controller of Budget, Parliament, and the National Treasury. You became a conciliator, went ahead, and so all those issues. So I was just wondering, if you became now the Chief Justice and you are not looking at the bigger picture, you're looking at the rights, yes, of one section of the society, but ignoring the bigger picture. I mean, how would that work, if I may ask?
I do appreciate your analysis of that, but there was also evidence from the other side, correct? From the workers. And the history since 1997 of denial. Agreements reached, denial for years. Salary negotiations agreed, given in installments in 5 years. So there was compelling evidence also from the workers, from the teachers of this country, who at that time were earning from 15,000 shillings a month. A majority of them not beyond 30,000, 40,000 bracket. So we had the evidence from the economists. We had counter evidence from the workers. We had reports from SRC. We had agreements at 50, 60%. During negotiations, I actually implemented what had been agreed upon, but reneged upon after SRC intervened. There was already an agreement at 50, 60% by parties, both parties. SRC stepped in and they reneged on that promise. That was the context of it. And as soon as my judgment was injuncted by the Court of Appeal, they engaged into negotiations, which have resulted in salary increments in the same line I had decreed. In fact, I believe still today, were it not for that decision, this is whether it was nullified after that, the situation of teachers would never have changed. Immediately before even the matter was over at the Court of Appeal, they had already started implementing. And it was implemented, and it's a fact today, all teachers got between 50 to 60% salary increment thereafter. And there has never been a major strike by the teachers since then. And that was my focus. Because we had suffered, the children had suffered so much, the parents had suffered so much every day. Every beginning of the year, there was a strike notice for a long period. So those are the facts which I took into consideration. I am not one to rock any boat. I've worked with governments for a long time. I've served the East Africa community for a long time. I'm very balanced. But
Actually, I don't have a problem with, taking decisions that are firm and all that. That's quite okay. I'm just trying to address the principles. It's so much about the principle, because when the matter went to the Court of Appeal was of a different view. That's why I'm trying to follow that, because one, you became a conciliator, which the Court of Appeal was saying is against the Labor Relations Act. As a judge, you can't be a conciliator. You judicial overreach. The court said that you usurped jurisdiction you didn't have. You took over the work of other institutions. So basically faulting everything that you are saying that you did right. Now my worry is that you are taking a firm position that you are right in most of the decisions, even when the Court of Appeal is saying it is taking a diametrically opposed position to you. So would it then be a case of...
Can I correct you first?
Go ahead, my lord.
When the matter first went to the Court of Appeal, it was handled by a bench of none other than Commissioner sitting before Wasame as a judge of appeal.
Yeah.
In fact, at that interim stage, upheld the decision and directed that it be implemented. Another bench was constituted.
5-judge bench.
To counter the decision by Justice Wasame's bench. So there's no, even at that level, there was no unanimity on that matter. So that is why I say that I may not have been right because I was corrected. One bench of the Court of Appeal and partly implemented that decision, overruled. Yeah. The government itself implemented the same, if not better terms as those. That is the reason why we got into some sort of court-annexed side mediation with agreement of the parties. What? Because there was already an agreement before court, signed by the parties, but nullified by SRC. That was the basis. That is what gave me, that was what was informing me that why did it, I mean, on balancing of the facts, that was a main consideration. That these parties had sat together for so many hours and days. They had hammered out an agreement. this agreement was about to start being implemented. And remember, there's a history of implementing these agreements in phases. That is what used to happen. They would agree on 50, 60% basis. Then they would then agree it will be paid in 4 years' time. So there was that history. And that is what was informing me. And I also had a lot of experience at Federation of Kenya Employers of hammering out CBA agreements. I have a great experience in this negotiating.
I agree with that.
So I was, it came from...
My worry, as I'm saying, is that you suddenly became now that conciliator who used to be at Federal Employers of Kenya.
Yeah, by agreement of the parties, and what I should have done, what happens in other jurisdictions was after that conciliation failed, in hindsight, I should have handed over the file to another judge.
Absolutely.
It happens all the time. In other jurisdictions. Judges can step in and conciliate, which is actually a very good thing if it is anchored in law. But as soon as parties decide that you can step in and bring them together, as soon as that agreement fails, then you pass the file to the next judge.
Right. And that's what now the 5-judge bench, which
in hindsight, that is what I should have done.
Chief Justice also participated in it, all observed. Anyway, that's okay. At least you accept that position. Now, my position is that, which is now leading to my next question. Now, as the Chief Justice, what assurance would you give this commission, and of course Kenya, because they're also watching, that if you made you the Chief Justice, that you'll be able to make decisions that always look at the bigger picture, because at the end of the day, it's a huge position. It's not a small. You are heading the arm of government, where every single decision you make has national security implications, not just on labor issues now, because now you are basically dealing with labor issues, but now you'll be dealing with bigger issues, where one single mistake could cost lives. It could cost, loss of jobs. It could cost, it can either make or break. You could make a decision that could either make, or you could make one that could break. So I do not know how what assurance you'd be able to give us so that as we retreat to decide with the Chief Justice, that notwithstanding other personal influences, I suspect probably the fact that your mother was a teacher could also have influenced you. I'm also influenced a lot by what happened to my mother as I grew up. We are all prejudiced, but you'll be the Chief Justice. I don't seek to be a Chief Justice. So I don't know how much assurance you'll be able to give. How you'd carry out your duties to ensure that you make a decision that look at the bigger picture at any given time.
First of all, our Constitution has got a lot of safeguards against impunity. There's no place for a dictator in our structure. Much more in the setup of the Supreme Court. There's no way as Chief Justice can have his way if it be unreasonable in that context. There's no room for a Chief Justice to stand there and pontificate unconstitutional and unlawful endings. Two, right from the university when I was gotten to steer, to bring peace within this in very turmoil, difficult situations. And I was able to anchor the university through a very difficult period. And all the students from corners of Kenya trusted me to do that as a very young man. And I did, without a single strike, without a single student being expelled, not even a disciplinary hearing, until when I left. And as soon as I went to School of Law, before 3 months were over, we had another one of the most violent riots as soon as the next chairman was elected.
Okay, now.
So, I have very safe hands. I have balance. I have a lot of balance. And those who have worked with me, especially at the East Africa community, including Justice Kihara, the Attorney General, who was my chairman of the East Africa Judicial Education Committee. where I developed many concepts to train judges in East Africa. And I actually delivered many trainings in all the 5 East African countries. Raising funds, developing proposals and concepts, getting funds from development partners, initiating training programs here in Kenya, Uganda, Tanzania, Rwanda. Justice Kehara as my chairman, representing the nation of Kenya. I have a lot of commitment in what I do. I have a lot of patriotism beyond, and that is why I had to come back, even when I had very good position down there in Swaziland.
I thank you for that, my Lord. I thank you for that. Now, you mentioned...
And lastly, one which I forgot to mention in my CV, which you have, is that in 2010, when the referendum process leading to the promulgation of the Constitution was challenged in the interim constitutional court by organizations which felt that that process which birthed our Constitution was not fair and just, and they lost their case at the interim constitutional court, they filed a reference to the East African community. They filed against the Attorney General of Kenya and against the Secretary General of East Africa Community, saying that the process which led to the promulgation of our Constitution and violated not only the laws of Kenya and also violated the East Africa Treaty. I was again called upon to lead the defense of this country in that case, which is in the first page of the East Africa Law Report. You've seen it? I led that defense of this country.
My Lord, you are serious impressive.
And we succeeded to defend the detractors of the promulgation of our Constitution.
I don't doubt your CV. It cuts across. I mean, it's really, you are widely exposed. That I have no doubt. Now, you mentioned something about the process of disciplining magistrates not being very clear. It's not, if it's there, it's not, you know, I think I'm just quoting your words. You said that if it's not there, you're not familiar with it. But I thought it's quite comprehensive under Schedule 3 of the Judicial Service Act, because it's very comprehensive about all the steps. Maybe application is not being applied correctly, but in terms of the steps, I'm not sure whether you are aware about it, just as a matter of clarification.
During when I dealt with the case Commissioner Judge was dealing with, I interacted extensively with those schedules before determining that case, and I'm aware of it. Yet, there's so much disaffection in the cadre in the manner they are handled.
Yes,
especially in terms of timelines within which you are suspended on half pay, sometimes without pay. It takes many, many months for you, sometimes even years. I had a colleague in Kisumu who I think had waited for 3 years.
Yeah, I appreciate maybe
for a case to be determined without salary.
Yeah, maybe it's not being applied expeditiously. The implementation, there could be a problem, but it's not that there's no
It's not
process.
What I'm talking about, I would want to do is to have the same way you have some simple documents developed and given to people with very precise and detailed of the expectations and steps to be taken and timelines that should a magistrate be suspended pending investigation, blah blah blah, this must be done this way within this timeline, and should it not happen, this should happen, this should happen. In other words, I'm not looking for another regulation. I want to champion development of documents, simple documents with the people, to be with us internally, to understand those processes, and so that if they are violated, we can say that why is a magistrate waiting for 3 years without pay?
I agree with you. I agree with you
Without
a lot
pay.
on that. Yeah, we agree with you. Now, the final point on that, I also had you mention that you talked about if you became the Chief Justice, you emphasize so much on the judges and the magistrates, but I didn't hear you talk about the support staff, who are a critical component that is normally ignored. And sometimes I get the impression that even as judges and magistrates are talking about themselves, they don't seem to appreciate that these enablers, the support staff, as important because their work will also determine how effective the judges and magistrates, will be able to do their work. I would also like to hear a bit, about that.
Yeah, thank you very much for that. Was an omission on my part, and actually prepared myself on it because I'm very passionate about every staff member. I'm aware of the directorates and the staff who serve below them at the lowest level, and I also looked at their levels of satisfaction in the report, which were not bad. The percentages in that cadre of disaffection, some were very high, of satisfaction were very high. And that's why I did not become very concerned, because if I'm to be guided by that report, if it speaks the truth, it appeared to me like there was a very high level of satisfaction within the administrative cadre. And but it's an area I should be able to interrogate and to follow upon, because I believe that if all the staff or any of the staff they are disgruntled, their issues are not being handled, especially the sanctions and the rewards. Another area I would want to talk about, for example, who knows what criteria is used for staff in the judiciary to be given national honors? Who knows which committee and who deals with it? I know there is one, but do we know? Do we know why some people have received 2 commendations from the president and others don't have one within very short timelines? Is it that the others are not deserving? Who deals with it? What is the criteria? Can we have a small booklet of 2 pages telling us this is a criteria of receiving state commendation as a judicial officer, as a magistrate, as a staff for the work you have done? These are the areas of disaffection where people quietly, because judges have no room to go out there and make noise. But it doesn't mean that they don't feel it. They're not, they don't feel it. They can see, and they don't know why this, not why that. But so what I advocate for is a transparent edicts, little procedures, transparent saying, this number of judicial officers have been honored by our president, and this is a criteria which has been used, and in the future, this is a path we are going to follow for that purpose.
All right. Thank you, my lord. I wish you well. That's all for me.
Thank you.
Thank you. Thank you, Commissioner Jero. Your Honor, we will take a short break.
Appreciate
maybe
it.
5 minutes. We'll come back, Honorable Commissioners, at 12:15. It's about 10 minutes. Thank you.
Yes, yes.
I shall not leave. I will sentence you to die. Don't do so. Do not kill my father, please.
Now see for yourself. It seems so very clear that even the gods are against your decision. Tonight on KBC Channel 1.
Kuna nyumba ambayo wageni hawafiki. Sasa jana ule msichana jana naye nini ulikuwa unamuuliza? Sasa ngoja mimi nini nikatokea. Msichana yupo na kukula ulimi ya ng'ombe.
Mbona mnataka kundi?
Sasa usikae kikundi kwa nini? Sasa nisiongee na mke yote ama mke yote sikuje kunitembelea, si ndio?
Wanaume watupa kula sana wake.
Landlord hataki kabisa mambo kama hataki wageni. Yaani unatanga nyama huko, lakini renti ya mtu unamcheleshia, unampa siku ile unataka.
Kama una shida nigongee mlango niendeleze shida yangu. Sio kupayuka tu kama umewekewa sijui nini kwenye koo.
Ni ungwana.
Tonight on KBC Channel 1.
What I need is something that can make Mariana lose her interest in him, and that rather makes him a victim.
Please just think about the speech you will have ready for my in-laws when you go to ask for Mariana's hand, huh?
Mom is a victim here. She gave you the family you didn't have when you had nothing at all.
Not she's shot. Amaya's been shot.
What do you mean she's been shot?
Divine, baby.
What you gotta do? That time of the week again where we grace your screens to bring you nothing but pure entertainment. Joining us on the show today is the one and the only Treasure, all the way from South Africa. My name is and I am a photographer based out of Nairobi, Kenya. It's all about celebrating the beauty and the boldness of who we are and how we live.
Next on.
Just see me as your family, not just see me as your friend.
Everything alright.
Journey to the ends of the earth. But the wish never burn that way. But the wish never.
The 200 meters title was taken by Jamaica's Shirley Ann Fraser-Price, who timed 22.17 seconds as she completed her double time.
This is a race where sprinter powerhouses like, among others, Jamaica, the USA, Great Britain have dominated for a long time.
Here come the Africans. Ahore leading through, but it's Shirley Ann Fraser-Price ahead of Ahore and pressing up Bari. History is made because Shirley Ann Fraser-Price does the double, but Africa takes their first medals as well in the 200 meters, and they get two of them. Alison Felix there pulled a muscle or tripped over or something halfway round the bend. Very unusual from her.
Other nations are coming up to challenge the status quo, with the youth picking up the mantle from the seniors, as I witnessed in the 2017 IWF Under-18 Championship in Nairobi.
It was inevitable that the male athlete would come through faster, but it's a question of whether the Kenyans can hang on to this lead. Mary Mora will do the last 400 meters. Quite capture.
Mary Mora, who is now a Form 4 student at Mabunga High School, was inspired by her sisters that are growing up inside Nyanza. She stood out in the school competitions, not only the 400 meters, but the 200 meters as well, to become the East African champion. The TC Express has been outstanding too in the Athletic Kenya meets while preparing to sit for her Kenya Certificate of Secondary School examinations as she looks forward to more glory in the international arena after the Under-18 Championship was arrested. So keep her on your watch list. Can you believe we get to come out here every day?
So what do we do now?
We take it day by day. I have to believe that something good is gonna come out of this.
Tonight on KBC Channel 1.
Namleta mgeni na mpangaji.
Tena namfanya hivi lakini
kwa leo tu, kesho tutakwenda kutafutia ile nyumba nilokuambia. Asimisha kutumia huo mzigo. Shukrani sana. Sasa shindwa mwenyewe.
kuna ile kule store.
Nina ile store hiyo kama kundalisha.
Tonight on KBC Channel 1.
Kuna nyumba ambayo wageni hawafiki.
Sasa jana ule msichana jana na nini ulikuwa unamuuliza?
Sasa ningotea tu mimi nikareply. Msichana yuko na kukula ulimi ya ng'ombe. Bwana mnataka kundi.
Sasa usikae kikundi kwa nini? Sasa nisiongee na mtu yeyote ama mtu yeyote asikuje kunitembelea, si ndio?
Wanaume watupa kula sana wanawake.
Landlord hataki kabisa mambo kama hataki wageni.
Yaani uko lakini renti ya mtu unamcheleshia, unampa ile unataka.
Kama una shida nigongee mlango nieleze shida yangu, sio kupayuka payuka tu kama umewekewa sijui nini kwenye koo.
Ni ungwana.
Tonight on KBC Channel 1.
I shall wait. I shall not leave. I will sentence you to die. Don't do it. Do not kill my father, please.
Now see for yourself. It seems so very clear that even the gods are against your decision. Tonight on KBC Channel 1.
What I need is something that can make Mariana lose her interest in him, and that rather makes him a victim. Just think about the speech you will have ready for my in-laws when we go to ask for Mariana's hand, huh?
Mom is a victim here. She gave you the family you didn't have when you had nothing at all.
Not she's shot. Amaya's been shot.
What do you mean she's been shot?
Divine, baby.
What you gotta do? That time of the week again where we grace your screens to bring you nothing but pure entertainment. Joining us on the show today is the one and the only Treasure, all the way from South Africa. My name is Tania Morel and I am a photographer based out of Nairobi, Kenya. It's all about celebrating the beauty and the boldness of who we are and how we live.
Next on.
Just see me as your family, not just see me as your babe. Everything alright. Journey, journey, journey to the ends of the earth. But the ocean never burn that way. But the ocean never. Nilishikilia kwa sana ndani ya matatu. Yaani mtu mzima na miaka zake hizo miaka zote. Mtu ajui kujua kuandika noti. NOT tu peke yake. Kusoma zote itasaidia baada.
Nini nakusumbua na nini?
Nauliza. Ni bwana.
Dia.
Mama Angel.
She goes through her strength training program with a determination that defies her age. Twelve-year-old Chanel Obiero has ventured into powerlifting and weightlifting, sports that were considered taboo for children until they were demystified by the benefits.
I got into weightlifting because I saw my mom doing it, and I told her if even me I want to do it. So when I saw her doing it at the gym, even me I told her, Mom, I want to try. And when I tried, I saw that it's good to do weightlifting. It can bring money. That's why.
Chanel is okay. At least she has an interest in the sport. She's very motivated to do the sport. A lot of things I do with her so that it just keeps motivating her to keep doing what she's doing. Unfortunately, I did not start at a young age as her. I started at 17. She had started at 9. From 9, she had already known what weightlifting was. She was already doing the techniques, and she had an interest to learn more about it. So it's an advantage for her now that she started at an early age.
Her mother, Mathews Obiero, was the first Kenyan woman weightlifter to compete at the Olympic Games, which inspired her to follow in her footsteps.
When I see what she's doing, I feel happy, and I like the way she represents our country, And even me, I want to be a champion like her. When she's old, me, I'm representing the country now.
She began lifting weights befitting her age and loved the experience from the start.
I started with the light weights. It was not that hard, but I tried.
Chanel participated in her first competition in 2019 to get her first silverwares, to the pride of her mom, family and school.
The competition was in Saika at a gym called Jaheka Health and Fitness. So when we went there with my mom, she was the one to compete, not me. But I tried to do squats with 40 kgs. When I started squatting, there's another man who saw me and said, I want that girl to be in the competition. So we started with deadlift. I started with 30 to 40 and then 50. And then we did squats. I started with 40 and then to 50. People cheered. We went to bench press. I did with 15 kgs. The one for village market was not a competition for me. It was for my mom, the strong man competition. I told my mom I want to try, and she told the other people to put for me weights. I've never tried to lift 60 kgs. In Jaheka, I lifted 50. When I tried 60, it didn't go up. So
based on needs assessment, there was interaction between the institute and all the stakeholders, the judges, the magistrates and staff on specific training needs, and the programs were developed at that point. And it appeared that there was a lot of funding in the training institute. I'm made to understand that most of it came from development partners because the budget from the exchequer was not enough. I know that is an area which belongs to JSC, training and development, and must say after just Mutunga left, I believe judiciary took a different focus on training, and I think there has been very little training during the period of Justice Maraga for reasons which I believe was specific focus of the Chief Justice himself on what were priorities, which I believe are well stated in the SJT. The focus was more on delivery of justice, backlog clearance, those deliverables, and training was not an emphasis. And I think also the funds were depleted, in my own view. So there's a lot that needs to be done, because as I said, judges need to be educated and consistently, and especially now that we have harnessed ICT solutions, there should be a lot of training based on those platforms, and there should be training needs assessment continuously conducted at every level, staff level, magistrates level, at judges, and programs implemented in a progressive way with minimal interruption of court sessions, because that was a major criticism, that judges are adjourning cases a lot to go to attend training. Training is a necessary component to develop the minds of all staff cadre, and it's a necessity, and it must be balanced with our main focus, which is to serve Wanjiko in the dispensation of justice.
Thank you, Judge. So what remedial action would you take as Chief Justice to ensure that the Judiciary Training Institute revitalizes such professional development?
I would immediately wish to get back to where we were during Justice Mutunga's time. I would want us to develop JTI to be supported through budget-wise, through initiatives that is why I spoke about having a principal mobilization, funds mobilization.
So funding is one, yes, thank you.
Anchored in the Chief Justice's office. Two, I want an initiative where there will be synergies between JTI and different stakeholders in the education, within the education sector, the universities, synergies between that school with the development partners who have always, I believe, been willing to support the growth and development of the judiciary. So I having been involved for 5 years at the EAC, in the training and development of judges. And I did that mobilizing the funds myself, developing concepts, motivate and proposals, interacting with the development partners and getting all those programs funded and outrolling them in the whole of East Africa. For those 5 years I worked, I have very good focus, and I'll be able to direct the appropriate stuff and to completely focus on rolling out again focused training programs for Judiciary Training Institute.
In your view, Judge, would you consider that the Judiciary Training Institute should be independent of the judiciary, as is, for instance, the Kenya School of Law?
Not at all. The Judicial Training Institute should remain part and parcel of the judiciary. That nexus, the fact that we have control of it, and therefore we will be able to be in charge of the programs and tailor them to our needs, is very, very important. Well, I don't think we should let go that facility as a judiciary.
Thank you. Let's move on to the 41 judges whom you mentioned. How would you use your diplomatic and negotiating skills to resolve that impasse?
You're right, Commissioner, that I have done a lot of consensus building in my work at the EAC, in my work at the Federation of Kenya Employers. I've negotiated with, at the level of senior officials, at the level of ministers, the whole of East Africa, and including at the level of the summit, the heads of states. And that's because that is how we developed documents at the EAC, through consensus. And so I know that heads of states do not deal with issues which have not originated from senior officials. A head of state wants to be confronted with an issue which has been mooted, discussed, issues narrowed, honestly and transparently from both sides. And I know the role of mooting that concept and bringing, narrowing the issues before they are presented to the head of state, who must eventually resolve this issue, must come from his very senior officials, some of whom this JSC is representative. And I believe some of the most critical senior officials to unlock are right here with us. And those are the ones that will engage immediately so that we come up with, within a very short time, with a framework which will narrow the issues so that we can even have talks about talks and agree that this is where we are. This is what judiciary is saying. This is what the president, the executive is saying. This is what is wrong. This is what is right. This is what is possible. And then we say, we are ready, let's go to the president with those issues. That's how heads of states work. They are too busy to be confronted with issues which have not been narrowed down. If you do that, you're bound to fail. So I, as a diplomat by excellence, I know how to deal with that. And I know how I will unlock it within a very short time. I know there's goodwill to do that, and goodwill is cultivated, it's built. It doesn't just come, you can't take it for granted. And that's part of a critical part of leadership, which I believe I am very strong in, Commissioner.
Thank you. And on the aspect which you also touched of these cases which are haunting judges and magistrates before the Judicial Service Commission, you gave us a recipe of what should be done going forward. How would you deal with the current backlog within the JSC so that what is pending is dealt with expeditiously?
I wish I was aware of the extent of the backlog, and that's an issue I will interact with immediately if I was appointed. But for a fact, judges are hurting, magistrates are hurting. The critical mass, our people of Kenya, may not have the correct information about this issue. The satisfaction index percentages about the service they are getting appear so good when I look at the 2019-2020 report. So therefore, why should our judges be so haunted that they have to take so much of their time to defend matters which, because of the decision they make as judges? Why don't we have, in the shortest time, a criteria to thrash out those issues and allow judges to do their work? And at the same time, communicate effectively to the people of Kenya that the independence of a judge is central to the dispensation of justice. And if that is threatened and eventually defeated, there'll be just anarchy. You cannot have judges having to look this way and that way to decide a matter because they're so afraid that tomorrow they will be before the JSC. We are getting to that point where judges and magistrates have to consider, do I make this decision? Because this party appears so confrontational that I'm almost sure that tomorrow I'll be before the JSC. Should now that become a consideration? It will be the end of the judiciary. We are about getting there, believe you me. And I would want, as soon as I am the CJ, to interact with the honorable commissioners. I'll be appraised on the pending issues and then determine those which have to do with the decision of making. Independence of a judge must be dealt with quickly. If there be matters of misconduct, serious misconduct, then we also expedite them. But issues touching on decision or independence of a judge are a threat to the dispensation of justice in this country. They will lead to anarchy. Remember the history of the judiciary, the star chambers in Europe, where judges were hanged because they made decisions. That is the history of judiciary and how independence of the nations decided that this institution must be guarded and defended so that it can be able to dispense justice to the people. We cannot afford to lose that. Thank you.
Thank you, my Lord. Speaking of independence and the delegation of sovereign power, what would you consider to be the role of the other two arms of government in protecting the independence of the judiciary?
First of all, the three arms of government are interdependent. There cannot be a government without the three of them, and all are born of the people, and they serve the people. We serve a common purpose in different roles. The authority we have at all those three levels is from the people. So there is area of commonality, and therefore, when decisions of the court issued fairly and justly, whether you agree with them or not, as an executive, please obey them and appeal. And because continued disregard of court decisions eventually leads to anarchy. And anarchy comes slowly, slowly, without knocking the doors. Issues of finance, financial independence of the judiciary, to unlock, and therefore the parliament is there to facilitate this institution, to foster its independence and service to the people. And that is why the interactions between the Chief Justice, the speakers of both houses, and the President himself are key, but in an amiable, constructive manner. And that comes of leadership styles, not to be taken for granted. To unlock finances from exchequer for purposes which are understood is so easy. But the manner of doing it is very important. To unlock matters which appear so difficult from the executive, it's so easy. But the leader must be able to deal with that in a professional, flexible way. And that is why I said the office of the Chief Justice is too important to have no structure in the organogram, that we only have ad hoc officers who come and go with the Chief Justice. We need a principal liaison officers, diplomat par excellence, to work with the Chief Justice every day, who should be a permanent officer in that office. We need a principal funds mobilization officer in that office, who will complement all the other directorates to come with a proper strategy of funds mobilization. And we need a legal officer, principal legal, in between the three of them to make sure they follow the law in doing so. And once the Chief Justice is empowered by those officers, he is able now to engage with Parliament, with the executive in an empowered manner to unlock these issues, Commissioner.
Thank you, my Lord. And how should the judiciary itself ensure that the other two arms of government discharge their mandate without undue interference? That's the other side of the coin.
There is a doctrine of judicial restraints, which I'm happy the Supreme Court has very strongly developed jurisprudence on, especially in the Karaoke Mate case, where they even have developed criteria which a judge dealing with matters pending before Parliament, National Assembly, Senate, county assemblies, the consideration to which a judge must take into account before they injunct them, they issue conservatory orders. We must ensure that we don't create unnecessary conflict we are interdependent, and we must allow, and all of us born of the people. So let Parliament do its work. Let the county assemblies do their work. Let the judiciary do its work. And let us intervene as and when it is necessary in terms of the dictates of the Constitution. We have been very well guided by the Supreme Court judges in that respect. And so everybody must read the Kariuki Mate case, and the edict by the Supreme Court, and the doctrine of judicial restraint. Then there will be harmony from our side.
And where would you place judicial activism in the development of the jurisprudence of the Supreme Court going forward?
As I said earlier, Honorable Attorney General, the Supreme Court is bound to implement the Constitution as is and to interpret it in a purposeful and harmonious manner without one part destroying the other. And the Constitution also has guided us in areas where we can fill gaps using the principles and values in the Constitution. So we're very well guided so that whatever gaps may be there, they have been, a question of activism does not arise. In fact, a judicial officer who does not want to obey the constitutional edicts is the activist, in my view, in the negative sense, because this Constitution was born out of sweat and blood, and we are bound to implement it as is, and we are very well guided in that respect in that document. So I do not see any danger in any Supreme Court judge deviating from that framework of the Constitution.
And finally, my Lord, why has the judiciary failed in the fight against corruption?
Again, I was very surprised again when yesterday I went through the court users report 2019-2020. And I was actually, it is with me here, I focused on that area of corruption. And the report focuses on corruption in the magistracy, corruption in the High Court and all superior courts, corruption in procurement, that's a directorate. I was so surprised, like within the procurement directorate, the level of satisfaction was 90% and above, in fact 92%. Unless there's something wrong with those, the manner the surveys were conducted. I was astounded because this perception there is that this place is completely corrupt. When I looked at the corruption indexes regarding magistracy, again, the satisfaction levels are over 70%. The same with the judges. Then I was asking myself, as I was preparing to come before you, where is this perception, which actually is so strong there that this judiciary is burning of corruption? When surveys are conducted and they seem to be saying something different. Given that, a 1% corruption is not acceptable in the judiciary. And so the proposals, the frameworks, the measurement, the accountability framework, which we have put in place, and is within 2019, 2023, plan. Those frameworks, they're very good framework, steps in curtailing, in enhancing accountability. within the judicial cadre, within the procurement area, and especially at our registries, because I saw the largest, the highest level of dissatisfaction was in the manner and the timeliness within which court users are treated within our court registries. That is where the highest level of dissatisfaction and is expressed, and therefore construed to be corruption is. So we give special focus, being informed by the survey, to have specific initiatives of accountability, working with the right directorates to enhance reduction of, to reduce, first of all, the corruption itself, and more so through the interfaces we have, the court users, the open days, every interface we have with our people, to educate each other on what we are doing, and so that they may also be fair to us as an institution which serves them when they judge us.
So if I understand you correctly, my lord, according to the statistics you've looked at, there is no corruption in the judiciary. But to use your own words, there is a perception, very strong perception out there, that the judiciary is rotten with corruption. So how are you going to engage out there to disabuse that perception?
Exactly. A big headache, because perception coming from years of a very non-responsive judiciary.
It's a big headache, yes. It's your headache now. You're the Chief Justice. What are you going to do?
First of all, whatever percentage of corruption is there must be dealt with very firmly. And again, synergies. We have our internal department of accountability, PPMU, and the framework they have developed is very, very key. All I'll do is try to enhance it. We shall have synergies, working interface with DCI. We shall interface with EACC and all other agencies which are concerned with transparency, Commission Human Rights, all organizations concerned with the issue of corruption, transparency, accountability. We shall engage them and and help us to develop, first of all, to communicate out there and develop.
But Judge, with respect, this has been done over the years. This is what the judiciary does. But the problem doesn't seem to be ending. What are you going to do differently to ensure that you get a result that erases that perception? Because if you look at the history of the judiciary over the years, Chief Justice after Chief Justice, but we still keep saying the perception is still there. To use your own words, it's very strong. So what is Chief Justice Nduma going to do so that in the course of his tenure, we can sit here and say that perception no longer exists or has been reduced substantially?
Chief Justice Nduma will not raise his hands and give up. The initiatives which are in our plan, strategic plan. I have seen what has been done. I have seen the challenges which have been developed. I will enhance the communication the interaction, the communication, how we communicate, and especially, I believe, through radio programs, because I think that reaches the greatest number of people. So we have to find better and effective ways of communicating to our people. How you cannot say that I appreciate the social media, but to how many people does it reach? I know the elite are all there, but we need to communicate to Wanjiku. I'm usually very impressed by the radio talk by the head of state of the United States of America. They usually talk directly to the people through radio, and it is still the most effective way of reaching to the farthest corners of the country. I want to come up with programs which will reach the largest number of people, but remember, we must be vigilant on whatever percentage is there on corruption. We must deal with it consistently by improving our measures which will stop any form of corruption, despite how small it is. At the same time, we'll continue getting feedback from the public, but I want our communicators to develop more and frequent and focused messages, especially through radio to the people of Kenya, and in Kiswahili, and even in mother tongue, to the people. We must, I believe, our communication.
Kupata sikiza tune hii ya Isaiah 48 kwa simu yako, bonyeza *811 *817#.
Wakati mwingine unaweza kujipata umefinywa pande zote na unaona kama shida yako ni kubwa sana, kama hakuna nguvu ambazo zaweza kuitatua. Lakini ni vyema kujua kwamba kuna Mungu mwenye nguvu na ambaye hachoki kamwe. Isaia mlango wa 40 mstari wa 8 inasema, je, wewe hukujua? Hukusikia? Yeye Mungu wa milele, Bwana muumba miisho ya dunia, hazimii wala hachoki, akili zake hazichunguziki.
Ili kupata sikiza tune hii, bonyeza *811 *817#, *811 *817#.
Je, umeomoka? Kama hujaomoka kwenye Quickbit ndio mambo yote. Hapa tuko na fridge, kodi yake ni CM. Tuko na gas cooker, kodi yake ni CA. Tuko na TV, kodi yake ni TV. Tuko na simu aina ya Samsung ni SM, ama Oppo ni Oppo. My friend, mahali popote unanitazama, eka hizo kodi zake kisha utume kwa 4032353. 4032353. Alafu utakuwa unaomoka na hizi bidhaa. Kumbuka, kwenye Quickbit ni bila bora zaidi kwa bei ya chini kwa chini.
KBC Channel 1.
What I need is something that can make Mariana lose her interest in him, and that rather makes him a victim. Let's just think about the speech you will have ready for my in-laws when we go to ask for Mariana's hand, huh?
Mom is a victim here. She gave you the family you didn't have when you had nothing at all.
Not she shot, Amaya's been shot.
What do you mean she's been shot?
Every Monday evening, we take you back where the action happened.
We cheer up your Monday blues.
Our cameras rove all week to cover the latest in the Nduma showbiz scene.
We show you what you missed even if you are present.
Grapevine gives 100% support to the local entertainment content.
From celebrity buzz,
music,
fashion,
and all manner of entertainment and youth talent.
Watch Grapevine every Monday at 10 p.m.
Remember what they say, if you did not see it on Grapevine, then it most probably
it never happened.
Je, umeomoka? Kama hujaomoka kwenye Quickbit ndio mambo yote. Hapa tuko na fridge, kodi yake ni CM. Tuko na gas cooker, kodi yake ni CK. Tuko na TV, kodi yake ni TV. Tuko na simu aina ya Samsung ni SM ama Oppo ni Oppo. My friend, mahali popote unanitizama, eka hizo kodi zake kisha utume kwa 4032353. 4032353. Alafu utakuwa unaomoka na hizi bidhaa. Kumbuka kwenye Quickbit ni bila bora zaidi kwa bei ya chini kwa chini.
A very good afternoon to you. We really appreciate you creating time to catch the latest right here on KBC Lunchtime News. A lot has been happening on this 19th day of April, the year 2021, and you're just in time for that and more in our comprehensive news bulletin that begins right now. Remember, you can be part of this at KBC Channel 1. That's our official Twitter and social media handle. And of course, at Safin_Cheng on Twitter, Safina Cheng on Facebook. That's where you can communicate with me directly. Of course, a lot lined up for you today when the search for the next Chief Justice of the country continues for a second week. Last week, we saw 5 candidates take to just answer some questions by the panelists. And of course, this particular week, 5 more applicants who are shortlisted for this position are going to be facing the panel to answer questions and ascertain why they feel they are best fit to serve this country as the next Chief Justice to take over from retired Justice David Maraga. Of course, this particular day, we are just going to be kickstart straight away by crossing over to just follow up on what is happening as Justice Nduma of the Employment and Labor Relations Court is the one now on the hot seat answering some pertinent questions as to why he is seeking to be the country's next Chief Justice. Let's listen in.
All the cadres, including judges, magistrates, and the staff. And also, to some extent, the budget that we had in 2010 or 2011 has also increased. Not so much, but it's reasonable. And you read about the surface satisfaction, but the Kenyans still are very much concerned that our service is below expectations. That's the reality on the ground, that the service that we give the Kenyans is still below expectations. I want from you, Judge, particularly coming from this Court of Employment, Labor Relations, and you are the chairperson of the Commission, to be very, very clear as you share the Commission, what we need to do, apart from that survey. What have we missed? What do we need to do different to ensure that our clients, the public, get some reasonable satisfaction in terms of our work.
That feedback, Commissioner, we get as a judiciary on the levels of satisfaction, the output, our work, especially the manner we are able to conclude cases from filing to judgment, and in other areas where we are giving service to the people. The demands we're getting from the public are not, there's the good and the bad of it. Remember, under Jaite, the Mutunga program opened up the judiciary on levels of transparency and accountability never experienced before in this country. And I believe the judiciary, if well judged, is the most open organ of government. That is double-edged because the more.
All right, there you have it. Justice Nduma Nderi doing all his best to answer some of the pertinent questions being raised by the panelists there concerning why he's seeking to be the country's next Chief Justice, of course, coming just a week after 5 other applicants, of course, also took that opportunity. That includes former Director of Public Prosecutions Philip Murgor, Justice David Marete Njagi, Martha Koome of the Court of Appeal, and Professor Patricia Kameri Mbote, of course, lined up in this particular week after Justice Nduma Nderi. Of course, tomorrow, in the coming days, will be Fred Ngatia, Justice William Ouko, Professor Wekesa Moni, and Alice Yono. All the way to Friday, we'll be bringing this particular interview live right here on KBC Channel 1 for you. Among the 10 applicants who will be the next Chief Justice, it's a matter of wait and see. Now, moving on, police have launched a manhunt for a man who is alleged to have stabbed his wife to death in the Kamulu area. Albert Baeche is reported to have made a call to their single-roomed house caretaker around 5:30 p.m. on Sunday, saying the wife wasn't feeling well, only for the caretaker to find the lady dead.
A manhunt has been launched for one Albert Maeche alleged to have stabbed and killed his wife in their single-roomed house in Kimulu, Nairobi County. According to the caretaker, the alleged killer, an often silent man, called him saying the wife was ill and needed some help.
Kwa hivyo tukamuinua, tukachukua makaratasi tukaanza kumpuliza. Hakuongea. Kwa hivyo wakati tumemuinua mkono, tumepata akivunja damu kwa makwapa.
Ni kama hayuko. Kushika hivi tungeuze tutoe nje tupepetee, tukaona damu saidi moja. Si ndio tulitoka tukapiga nduru.
Neighbors and residents now calling on couples to resolve their domestic issues amicably instead of resorting to murder.
Ni vibaya sana. Afadhali hata watu waachane roho safi kuliko kuua mwenzako. Afadhali tu niambie toka mwenzangu nini nimechoka enda zako.
Afadhali umwambie aondoke muachane kiroho safi kuliko kuchukua hatia mkononi watange mtoto wa wenyewe na alama ama umumalize.
Elsewhere, a family in Nguni Mwingi East Sub-County in Kitui has pleaded with the National Police Service to investigate and bring to book those involved in the murder of their 85-year-old kin. Ndawa Mbuvi was found murdered a few meters from his home 2 weeks ago.
Askari wakakuja wakapiga picha na ripoti, hakuna ripoti yoyote tulichapata. Sasa tukashindwa, tuko na serikali lakini haitusaidii bwana. Sasa tunataka waambie kama wamepata mwenye amehusika.
Sioni vile anaweza kufa katikati ya watu hapa. Na serikali ina ujuzi wa kufuatilia. Tena mkubwa sana.
Mwingi Sub-County Police Commander Joseph Yakan said investigations have kicked off and called on residents to aid the authorities with any information that may help arrest the culprits. Yusuf Farr, Channel 1 News.
Thank you, Yusuf, for that report. Now, from matters crime to matters COVID-19, a section of political leaders are calling on the government to step up the vaccination drive in the country. Led by Gatundu South Member of Parliament Moses Kuria, the leaders are calling on the government to use the lockdown period to vaccinate more people to enable the reopening of the country's economy.
Gatundu Member of Parliament Moses Kuria is calling for a robust vaccination drive in the country during the lockdown of the disease-infected zones. Kuria says with more people being vaccinated, the restrictions in place will be eased, hence reopening the economy.
To the Minister, to the Cabinet Secretary for Health and the Cabinet Secretary for the National Treasury to set aside 18 billion shillings so that you can be able to vaccinate all Kenyans who are above the age of 18. And because once we do that, it's actually a saving. It's not an expenditure. Because once we do that, we can now comfortably reopen the economy fully.
Murang'a Senator Irungu Kang'ata, on the other hand, recommending the inclusion of farmers in the priority groups for vaccination, citing their vital role in the economy.
I have seen sportsmen and women who happen to be young people, aged about 20, 30. They are now being vaccinated on priority basis. For me, I would be pushing government to include farmers. Murang'a, we are one of the most productive counties in Kenya. And therefore, if you don't protect our farmers, there's every likelihood agriculture can collapse.
The leader spoke at Kandara constituency during the funeral of activist Philip Njuguna Ruth, who succumbed to COVID-19. Nancy Okware, Channel 1 News.
Elsewhere, a section of members of parliament allied to the deputy president have hinted at popularizing the United Democratic Party at the grassroots ahead of the next general election. Kachibela Member of Parliament Mark Lomonukulol, who has since shifted from Party of Development Reforms, says that West Pokot is in the process of opening UDA offices that will be followed by a mass registration exercise.
Kachaliba Member of Parliament Mark Lomunokol, who recently decamped to the UDA party from the Party of Development Reforms, says United Democratic Alliance officials in West Pokot County are in the process of opening offices that will be followed by mass registration exercise.
Our intention is to reciprocate for the good deeds that we go through His Excellency the Deputy President. This party being associated with him, we are fully behind it.
The MP claims the aim is to ensure that all elected county leadership in 2022 come from the UDA party.
And as the sitting MP with the same party, we are committed to ensuring that leadership of 2022 comes through this party.
Mimi nimeshughulika na niko na wamama zaidi ya 200 kwa West Pokot County, ambaye wengine wanatoka Sigor, Kachalipa, lakini hatuja kutana, lakini tumeandikisha hiyo UDA ambaye tunaita Dr. Ruto Movement Women League.
Meanwhile, Nambale Member of Parliament John Bunyasi has hit out at those claiming that the One Kenya Alliance is no longer intact. The MP claims the allegations are purely propaganda from a section of political leaders from other formations who are jittery of what is coming next.
One Kenya Alliance itakuwa na utaratibu wao wa kuangazia ndani na kuchagua ni nani atawaongoza. Hawatawaambiwa na watu wengine. Na wale watu ambao wanajaribu kusema ni fulani tutamuunga awe ndani, hawana interest ya wana Kenya. One Kenya Alliance inaanzishwa kwa sababu zile alliance ambazo ziko sasa hazihudumii wananchi.
For Channel 1 News, I'm Gladys Mongai.
And some good news, a rescue center in Samburu County is in celebration after 7 girls who are on the verge of early marriage posted exemplary performance in the 2020 Kenya Certificate of Secondary School Examinations. The girls, who scored between 257 and 376 marks, vowed to pursue their dreams to the fullest to prove society wrong.
Samburu Girls Foundation in Samburu County. Jubilation filled the air. This is after 7 girls from the rescue center passed their 2020 KCPE examination, scoring between 257 marks and 376 marks. The 7 were part of a group of 11 who were rescued from early marriage and female genital mutilation.
The reason I joined STF is because Claire rescued me from child marriage. I went through it, but it was when I was almost to go to FGM and marriage, Mom Claire came to my rescue and I was able to overcome it.
I was about to be circumcised and Mom Claire came to my rescue. It was very hard, but when I came to school, it became easy because I developed my brain.
Wazazi wangu hawakuwa wanataka mimi niingie shule, walikuwa wanataka kunioza nipate mzee, lakini Mama Claire alikuja akanisaidia nikuje shule.
The girls expressed their joy, promising to pursue their life dreams.
We've had new cases and so many people reaching out for rescues to FGM and early marriages because of the break. It was long, and then we've had our girls who got pregnant, but we still support them. They're still under our care, but they're at home, but we still provide for them.
Finally, private schools in Gucha sub-county continued to post commendable grades in KCPE despite challenges posed by the COVID-19 pandemic.
Tumefurahishwa kwa sababu watoto wetu karibu wote watapata nafasi nzuri katika shule nzuri katika sehemu mbalimbali za taifa letu tukufu la Kenya.
Wanafunzi wa kwetu hapa, alama zao waliopata alama zaidi ya 400 ni wanafunzi 5, lakini hata hivyo matokeo yalikuwa mazuri zaidi kuliko mwaka uliopita, na hata hivyo wanafunzi wetu ni wenye heshima na taadhima ambao wanafuata nasaha, na hasa mimi nawapa kongole.
Reporting for Channel 1 News, I'm Jackie Wambiru.
Really good news there. Congratulations to all the candidates who sat for the 2020 Kenya Certificate of Primary Education examinations and posted such exemplary results. Now, moving on, a non-governmental organization in Kakamega County has helped set up gender desks across 13 sub-counties to help deal with increasing cases of the virus. Speaking while distributing dignity kits to Kakamega Police Station, the organization's Chief Executive Officer, Steve Amusala, noted that collaboration between various partners in this area is key in ensuring that such cases are dealt with conclusively.
To safeguard the dignity of sexual violence survivors in Kenya, the government introduced gender desks to address gender issues which need privacy in police stations. As part of actualizing this desire, African Development Services Mwendo, a non-government organization working in Kakamega, has partnered with police to set up and strengthen gender desks across the 13 sub-counties. Steve Amusala, the CEO of ADS Mwendo, said the initiative will help ensure that the system of reporting cases of gender-based violence is handled with the sensitivity it deserves.
We thought that it was very important for us to train police in terms of how to deal with these children. Very interesting to mention is that we were able to set up gender desks across the 12 sub-counties or to strengthen them, and we had a training even to that effect.
Rose Mohanda, a health officer in the area, noted that most cases, especially involving violence against children, have been compromised due to loss of evidence, noting that the distribution of dignity parks in police stations will help remedy the situation and ensure victims get justice.
For children to have justice, evidence preservation is very important. So when they come to the police and we require that the materials, particularly clothing they are in, are supposed to be changed, then we need something to change.
Material will be distributed among the 13 sub-counties for Kakamega County. And we urge other stakeholders to come and assist.
Data from the Kenya Demographic and Health Survey shows that 45% of women and girls face a form of gender-based violence or another annually in Kenya. Caroline Kamau reporting for Channel 1 Lunchtime News.
Right, and that report takes us to our first break right here on KBC Lunchtime News. Please don't go too far. We still have more coming up.
Je, umeomoka? Kama hujaomoka kwenye Quickly ndio mambo yote. Hapa tuko na fridge, kodi yake ni CM. Tuko na gas cooker, kodi yake ni CK. Tuko na TV, kodi yake ni TV. Tuko na simu aina ya Samsung ni SM ama Oppo ni Oppo. My friend, mahali popote unanitazama, eka hizo kodi zake kisha utume kwa 4032353. 4032353. Alafu utakuwa unaomoka na hizi bidhaa. Kumbuka kwenye Quickly ni bila bora zaidi kwa bei ya chini kwa chini.
Tonight on KBC Channel 1.
Kuna nyumba ambayo wageni hawafiki. Sasa jana ule msichana jana na ile nini ulikuwa unamuuliza? Sasa nikotoa mimi nikakubali. Sasa yuko na kukula ulimi ya ng'ombe.
Bwana meka kundi.
Sasa usikae kikundi kwa nini? Sasa nisiongee na mtu yeyote ama mtu yeyote sikuje kunitembelea, si ndio?
Wanaume wakipa kula sana wake.
Landlord hataki kabisa mambo kama hataki wageni. Yaani unachanga nyama huko, lakini renti ya mtu unamcheleshia, unampa kile unataka.
Kama una shida nigongee mlango nieleze shida yangu. Sio kupayuka tu kama umewekewa sijui nini kwenye koo.
Ni ungwana.
Boom, boom, boom. Yeah, greetings massive and cool. Welcome to the Big Bad Show. This is the Rave. We are Radio Mix TV each and every Wednesday live on KBC Channel 1 and KBC Radio Taifa. You see me? This is where we play the latest and the greatest from homegrown artists to international reggae stars.
Checking the rave with Junior Dread and DJ Stano
Every Wednesday from 10 p.m. If you blink, you miss the link.
And on this second part, we take you to the coastal region, where Mombasa Governor Ali Hassan Joho says the coastal political front remains relentless in its quest to formulate a unity party in the near future. Joho claims the political drive has hit a snag due to the raging pandemic. However, the setback may not have dampened their efforts towards its realization.
Alleged fruitful State House meeting led last March by Mombasa Governor Hassan Joho, his Kilifi counterpart Amason Kingi and Kwale Governor Salim Vuria was portrayed as an endorsement by the head of state towards the realization of the Coast political party. Proponents of the outfit argue that the party, which is set to be launched in June this year, will resonate with the needs of the locals. However, it appears that the three political factions have stepped on the brakes on the formation of the said political outfit. Mombasa Governor Hassan Joho says the core principals have their sights fixed on realizing the agenda, calling for patience from their constituents.
Tumesimamisha mikutano hasusan only because of COVID. You can be rest assured, if it were not for COVID, the team is growing to be even bigger. People now are coming on board for all of us to speak with one voice.
Speaking during an iftar in Jomvu constituency, Joho called on Muslim faithful across the county to look after the less fortunate as well as adhere to health protocols in place during the Ramadan season.
Bunge wetu wa Jomvu alipopata corona ametoka akawaambia Wakenya wengine yeye amepata corona. na sasa yeye amepona. Mimi naomba iwe funzo kwa wengine wote kwamba ukipata corona is not death sentence. Ukipata corona is not shame, si aibu. Ni kwamba ujifiche. The best thing to do is to learn from it and protect others.
Area leaders led by Jomvu Member of Parliament Badi Twalib called for immediate interventions for Muslim faithful during the Ramadan period, citing hard economical times owing to the raging pandemic.
Serikali through special program waangalie nao pia wataweza kufanya vipi. Ni jambo la Kiislamu kwa ni collective responsibility. Kila mwenye uwezo amsaidie mwenzake ili kuona kwa wanaweza vipi kusaidiana na watu wakati huu mgumu wakaweza kuishi pamoja. Msaada wa njia yoyote kwa mwezi huu mtukufu wa Ramadhani hatujalenga tu kwa Waislamu peke yake, lakini Muislamu na hata ambaye si Muislamu pia ni binadamu ambaye anastahili kuishi na kuona kuwa hali ya maisha inakuwa sawa.
Juni Karisa Mbele from Mombasa County.
And now to Baringo County. The Baringo County government and Kabarak University have partnered to improve the quality of health services in the county. The agreement will see the digitization of various health services and training of service providers. Baringo Governor Stanley Kiptis said it was high time the county embraced technology in the provision of health services. Kabarak University Vice Chancellor Professor Henry Kiplagat said the 3-year project will encompass areas such as research, maternal health, among other areas.
We have also partnership with Nairobi University and USAID on health information systems that we are going to put in place because we want to embrace technology. So we are digitizing our health facilities so as to allow us monitor our services in prevention of drugs and as well as the human resource.
We also need to go beyond what we signed today under the MOU because there could be other teething problems that the county government of Baringo may identify in the area of health. Listening to His Excellency the Governor earlier on, I mentioned that there are shortages even when it comes to nutritionists and dietitians.
And over 4,000 tree seedlings have been planted at Kalro Non-Ruminant Center as part of a move to support Kenya's initiative to attain 10% forest cover by 2022. The seedlings planted were from Non-Ruminant Research Institute under the government's greening initiatives.
And you realize that the dependence on firewood has continuously dragged this behind because people keep on cutting trees and they're not replanting them. So I would appeal to the people living close to forests, as much as probably there is the diminishing land for agriculture, they should also be considerate to the trees.
So kwa leo tuko hapa Kaldo tunapanda 4,000. Hiyo ni ile miti tumedonate kama bank.
As Kenya Forest Service, we have about over 1 million seedlings which are ready for planting this year. And also with other stakeholders, institutions and private nurseries are also having over 4 million seedlings. So totaling to 5 million, which we are targeting to plant this year within Kakamega County.
It's now time for us to focus on matters business, and to kickstart this, we just want to cross over straight to the Kenya Power Towers. We got our reporter Alan Aoko, who has been following up on a story that is really interesting, and this touches on system losses by the Kenya Power being reported this morning. A very good afternoon, Alan. Kindly bring us up to speed with this particular report on the losses reported by the Kenya Power and Lighting Company, and also just shed some light on some of the strategies they have to curb this going forward.
did at the power utility, Kenya Power. In the recent months, you have probably seen operations to do with illegal connections and what have you. This is in efforts to safeguard against risks of loss and tampering of the infrastructure that has been put in place by the power utility in its efforts to bring power to the country. But there's also other losses that are occasioned, and this is system losses in the system. And we want to understand what these losses are and how they are being mitigated by the power utility. And just to expound that for us, we have with us the engineer, Margaret Kanini, who is the manager of sales at Kenya Power. Yes, so the engineer will explain to us, just explain to us the update that you've given us this afternoon, this morning, as the media, about the losses and what you're doing about it.
Yes, the losses have actually gone up. We are currently at around 24%, and this is occasioned by the network expansion. You know that currently now Kenya is over 60% electrified, so the network has really expanded. That has caused what we call technical losses. And we also have another kind of theft called commercial losses. That is what is lost through theft of electricity. And that is at the metering point, where we have people stealing electricity and using it when it's unmetered. Another one is where we have tampering of meters, which is also very, very rampant. Thank you.
Yes, you spoke of the losses coming in terms of commercial losses. Can you also bundle the losses that come with perhaps maybe defaulting? We saw 16% of defaulting, in a rise of defaulters in the network. Perhaps going forward, what are some of the mitigations in place to arrest this situation?
Yes, we have various activities that we are doing. Probably you have seen a lot of operations on the ground. Countrywide, we have declared war on these losses, and our officers are all over the country every day trying to curb these losses by uprooting illegal lines, by metering what has not been metered, of course using the laid down procedure, and also making arrests for those who are found to be culpable. So that is what we are doing, in addition to using technology to be able to inform us where electricity is being stolen, using smart metering. We are currently working on a project to implement 55,000 meters to our SME customers, and that one will assist us to curb losses. So going forward also, our large power customers, all of them are going to be on smart metering, and in the medium term, we also expect to put all other customer categories on smart meters. The advantage is that the smart meter will be able to tell us or to alert us where we have any tampering of the infrastructure, like metering. We'll also be able to know if the consumption patterns of these meters have changed, in addition to many other advantages. Thank you.
So will this advanced metering system be instantaneous, such that the information is going both to Kenya Power and to the consumer as well?
Yeah, this system is instantaneous. When something occurs to the meter, an alert is sent to of course, Kenya Power. The customer will be able to see only what is.
Thank you very much.
And also, why are you?
Thank you very much.
That is what you want to do.
Alan Aoko there, just following up for us this news this particular morning. Kenya Power reporting losses of about 25% and talking about plans to curb this, which include the uptake of smart meters that consumers are going to be put on smart meters, which according to the officials there is going to help monitor issues such as tampering and consumption patterns. A lot will be coming your way in our subsequent news bulletins on that story being worked on by Alan Alan Aoko. Now, moving on to matters tourism, hoteliers in Malindi are calling for strict adherence to the COVID-19 safety measures laid down by the government to avert travel advisories from key source markets. In April, the UK issued travel restrictions to international arrivals from 4 countries, including Kenya, Bangladesh, Pakistan, and the Philippines, as part of measures to stem the spread of COVID-19.
For its remarkably picturesque tourist attractions and unparalleled safari experiences with national parks and game reserves, making the country a premier destination for wildlife and adventure seekers. However, travel restrictions born out of the COVID-19 pandemic have adversely affected the sector, resulting in significant trend of decline in new bookings and large-scale cancellations of existing bookings.
We see that in 1 year we count losses in all hotels and restaurants and activities, and now the problem is becoming more in Kenya than in Europe. This it worries us. UK works good to reduce, and now they are banning Kenya and travels to Kenya. USA is doing the same. We hope Italy is not going to do the same.
In light of this, hoteliers in Malindi are anxious over non-compliance of COVID-19 safety measures. Early this month, the UK issued travel restrictions to international arrivals from 4 countries, including Kenya, Bangladesh, Pakistan and the Philippines, as part of measures to stem the spread of COVID-19.
Malindi and Kilifi County, but Malindi specifically, depends sana na tourism. And of late tumeona tourism hapa imekuwa affected sana kwa sababu most of the tourism initially were coming from Italy. And right now we are depending on tourism from Nairobi. So with the lockdown, the tourism has come almost to zero.
They argue that the industry is already struggling to keep afloat as COVID disruptions bite. Already the United Kingdom imposed sanctions on Kenya, and there are fears that the USA could also do the same. Under the travel restrictions, international visitors who have departed from or traveled through the red list countries in the preceding 10 days are refused entry into England. Countries on the list include Brazil and South Africa, where 2 of the most concerning various variants have been identified. Kenya was the last connecting hub in the region to be put on the UK red list, which contains 39 countries that have been banned or restricted to control COVID-19. In Eastern Africa, Tanzania, Rwanda and Ethiopia had already been placed on the red list, and Africa's main connecting transport hubs, Johannesburg, Nairobi, Addis Ababa, as well as Dubai and Doha in the Middle East are now on the UK list. Regina Manyara reporting for Channel 1 Business.
Moving on, I&M Holdings has been ranked as the most attractive bank in Kenya, followed by Equity Group and Absa Bank. According to the banking report released by Saiton Investments, I&M topped was supported by a strong franchise value and intrinsic value score. Here is the report.
The report themed subdued growth in earnings amidst deteriorating asset quality, looked at financial results of the listed banks for the year 2020. Asset quality for listed banks for the year 2020 deteriorated, with the gross NPL ratio rising to 13.5% from 10.5% in the financial year 2019. This was due to the economic slowdown as a result of the pandemic, which led to an uptick in the non-performing loans. Anne Washera, investment analyst at Saiton Investment, says the proactive stance taken by the banks in monitoring their loan books, coupled with the measures implemented by the central bank, will continue to support the sector's growth, adding that in the medium to long term, banks will continue over-provisioning, although at a slower rate. I&M Holdings took the top position in the weighted score of both franchise and future growth opportunity perspective, having a better capacity to generate profits from its core business. The franchise score measures the broad and comprehensive business strength of a bank across 13 different metrics, while the intrinsic score measures the investment return potential. Equity Group recorded an improvement in the franchise value ranking, coming in second mainly on the back of a 52.2% increase in the group's non-funded income, coupled with an improvement in the bank's NPL coverage, which recorded a 10.4 percentage point increase to 62.4% from 52% recorded in Q3 2020. Absa rank improved to position 4 from position 7 in Q3 2020, attributable to the bank having the lowest NPL ratio among listed banks at 7.7%.
And now crossing the borders, Facebook is set to announce a series of products under the umbrella social audio this week, including its take on audio chat app Clubhouse and a push into podcast discovery and distribution. This comes hot in the heels of competitor Twitter that has been testing its audio feature spaces. Here are the details of this and other stories from across the globe.
Under the Facebook upgrade, the Clubhouse-like product will let groups of people listen to and interact with speakers on a virtual stage. Facebook will also launch a product allowing its users to record a brief voice message and post them in their newsfeed, and a podcast discovery product that will be connected with Spotify. The announcement will be made on Monday, but some products will not show up for a while, as 10 million weekly active users has demonstrated the potential of audio chat services, particularly during the COVID-19 pandemic. Twitter has been testing its audio feature spaces, and Facebook is also dabbling with a live audio room offering within its messenger rooms. Meanwhile, China State's Plan, a National Development and Reform Commission, approved 16 fixed assets investment projects worth a total of $6.96 billion in the first quarter of this year. The projects are mainly in the transportation, high technology, and energy sectors. China power consumption surged 21.2% in the first quarter from a year earlier. Finally, Eurozone government bond yields were broadly steady on Monday, with markets largely on hold ahead of this week's European Central Bank meeting. New supply estimated at over $36 billion this year and above the average for the year so far. However, significant moves were likely to be limited ahead of Thursday European Central Bank meeting, which has stepped up the pace of bond buying in its pandemic emergency purchase program since the March meeting to contain a rise in borrowing costs that could derail the recovery. Terry Njenga, Channel 1 Business.
Now, still staying on the global scene, Russia has announced that 20 diplomats from the Czech Republic will be expelled after the Czechs expelled 18 Russian diplomats. The Russian diplomats are suspected of being intelligence operatives involved in an explosion at the Czech arms depot in 2014, which killed 2 people. 2 Russians suspected of carrying out a nav agent attack in the UK in 2018 are now also being linked to the blast.
A statement from Russia's foreign ministry called Czech decision unprecedented and hostile act. Czech authorities says the diplomats are believed to be intelligent operatives, accusations the Russians have classed as unfounded and absurd. The explosion tore apart ammunition storage depot in a forest at Vabatis in Czech Republic on 16th October 2014. Elsewhere, a wildfire on the slopes of South Africa's Table Mountain has spread to the nearby University of Cape Town campus, forcing the evacuation of hundreds of students. The blaze spread quickly as a result of low humidity and dry bush destroying properties of an unknown worth. Investigations show origin of the fire was from a vacated vagrant fire. Meanwhile, India's capital Delhi has announced a week-long lockdown after a record spike in cases overwhelmed the city's healthcare system. Government offices and essential services will be open during the lockdown, which starts on Monday. The city reported its highest single-day spike so far on Sunday at 24,462 cases. India has been reeling from a deadly second wave since the start of April. Finally, tearful reunions filled Auckland Airport on Monday as residents from Australia were able to travel freely to New Zealand for the first time in more than a year. The long-awaited Australia-New Zealand travel bubble means visitors no longer need to quarantine on arrival. Thousands of passengers were booked to fly between the two nations on Monday. Both countries have contained COVID outbreaks and kept infection rates low, largely due to tight restrictions.
It's time for us to focus on the sports news. Safari legend Carl Flash Tundo is set to make his R5 debut at the FIA ARC Equator Rally, slated for the Great Rift Valley on Saturday and Sunday. Tundo, who has been running a Mitsubishi Lancer Evolution 10 R4, will now be upgraded to one of the 7 R5 supercars enlisted for the event.
The VW Polo R5 car was to be driven by Oman-based British driver Pratul Goose, who has instead opted out due to logistical challenges. Tundo's new drive is something related to the monsters his teammates Javier and Onkar Rai are currently running on Kenyan soil. Tundo has won the Safari 5 times in the ARC days, while Ian Duncan emerged the winner in the WRC Kenyan edition of the event in 1994, navigated by Dave Williamson from Mombasa. Equity Extravaganza will use 6 stages from the grueling WRC Safari route. The 6 are Elementaita, Soisambu, Sleeping Warrior, Loldia, Malewa and Kedong. WRC Safari stages omitted from Equator's 2-day schedule are Kasarani Super Special Stage, Oserian and Hell's Gate Wolf Power Stage.
No expectations, but I'm hoping I can. I've said a lot about these cars and how I would love to be in one. So now the proof will be in the pudding whether I can drive the thing.
Is a call for your generous giving. The family of Sofapaka midfielder Wisdom Naya are now calling on friends and well-wishers in the country to extend their support towards raising funds to cater for their son, who has been ailing from a tumor. Now, the family, parents are further explaining that their son has had to undergo treatment after 3 weeks, which costs more than 55,000 shillings. The parents say they cannot afford to raise the money as they are casual workers.
Tibabu kama sisi familia, ukweli ni kwamba hatuwezi, maana mimi kazi yangu ni mwanajua kali hapa mjini Kitale na mapato yangu pia ni kidogo. Kwa hivyo kuraise shilingi 55,000 baada ya wiki 3 ni changamoto kubwa sana kwangu.
Na tangu wakati huo tumekuwa tukifanya different tests kutoka Disemba, tumefanya tests tofauti ambayo ni gharama. Tukiwapigia pia wana respond, wanatusaidia. Kwa sasa wakati tulifika, daktari akatuambia sasa aanze chemotherapy kwa sababu hiyo kidonda tutaki tukimbilie surgery ili deform hiyo mguu. Achaanze chemo kwanza ipunguze huo uvimbe. Na wanasema it's a type of a sarcoma, a tumor that when you ask them nini na cause, wanakuambia hata hawa bado hajajua ni nini na cause sarcomas kwa sababu ziko different classes.
Sofapaka wamekuwa wakishughulika kwa hizo test nimekuwa nikifanya kama MRI, biopsy, wamekuwa nashughulika, lakini sasa ni vile bili ilikuwa mob ndio tukaamua kusika. Well wishers pia kama wanaweza come through.
We hope that help will come your way soon for you to receive the treatment you need, Wisdom. Now, moving on, Atletico Madrid strengthened their grip at the top of La Liga with a convincing 5-0 win over struggling Eibar, a win that saw Diego Simeone's side stay top ahead of rivals Real with 7 games to play. Meanwhile, Thibaut Courtois made a number of important saves as depleted Real Madrid held Getafe to a goalless draw, enabling them an a point that keeps them in touch with La Liga leaders Atletico. Now, Arsenal, Chelsea, Liverpool, Manchester City, Manchester United and Tottenham are among 12 clubs who have agreed to join a new European Super League. The Premier League clubs will join AC Milan, Atletico Madrid, Barcelona, Inter Milan, Juventus and Real Madrid. However, the UK Prime Minister Boris Johnson, UEFA and Premier League condemned the move when the news broke on Sunday. Critics say the move is being driven purely by money and would destroy domestic leagues and is against the integrity of the sport. UEFA, Europe's governing body, has warned that players involved will be banned from all other competitions at the domestic level. Now, Leicester City boss Brendan Rodgers says his side have a chance to create history after reaching their first FA Cup final since 1969 at the expense of Southampton at Wembley Stadium. Kelechi Iheanacho's second half goal proved decisive for the Foxes, whose last major final of any description came in 2000 when they lifted the League Cup. Meanwhile, in the English Premier League, Manchester United continued their fight for the league title with a comfortable 3-1 win over Burnley.
After beating Southampton 1-0 in front of 4,000 fans at the Wembley Stadium last night. The Foxes created the better chances in the first half through Jamie Vardy. However, the striker failed to take his opportunities as the half finished goalless. Southampton also failed to register a single shot on target in the first half, but Kelechi Iheanacho broke the deadlock in the early minutes of the second half, putting the Foxes in control of the game and also secured a final spot. The Foxes will now be looking forward to win its first ever FA Cup in the final set to be played on May 15th against Chelsea.
And that's all we had for you. Thank you so much for watching. Enjoy the rest of your afternoon. My name is Afin Acheng Ouma.
Vera Beauty and Fashion College, with branches in Nairobi, Eldoret, Thika and Meru. Did you know that we are a TVET approved institution? We offer courses in fashion design, interior design and soft furnishing, event decoration, flower arrangement, event planning, hairdressing, barbering and dreadlocks, beauty therapy, makeup, nail technology, spa massages, teaching skills, TOT, solo business management, and many more. Register now and visit our website on www.verabeautycollege.com. You can also call on 0725-923-550 Nairobi branch, 0728-087-689 Eldoret branch, 0722-227428 Thika branch, 0725-000 706 Meru branch. Vera Beauty and Fashion College, a TVET approved institution. Je, umeomoka? Kama hujaomoka kwenye Quickly ndio mambo yote. Hapa tuko na fridge, kodi yake ni CM. Tuko na gas cooker, kodi yake ni CK. Tuko na TV, kodi yake ni TV. Tuko na simu aina ya Samsung ni SM, ama Oppo ni Oppo. My friend, mahali popote unanitizama, eka hizo kodi zake kisha utume kwa 4032353. 4032353. alafu utakuwa unaomoka na hizi bidhaa. Kumbuka kwenye Quickly ni vila bora zaidi kwa bei ya chini kwa chini. Ilayska umada.
Difficult balancing act must be there to protect especially the decisional independence of a judge. The moment that goes, we will all close our offices and go home. It will be chaos. And we often take that for granted. We are informed by history so that we never fall into the same pitfalls of the past. And it's true, I really appreciate the role of this commission in ensuring that judges and magistrates are accountable to the people of Kenya who gave this authority unto us. What I am saying is, as a Chief Justice, working with you commissioners, I want to make sure that those processes do not hurt the judicial independence of judges, because that is so central to the administration of justice. And the people well educated would never want to touch it, because they will be the victims and defeat them without the judiciary and judges protecting them, and magistrates and all judicial officers.
We agree with you, Judge, and I agree with you. There's a question of protecting that independence, but also making sure there's accountability. And I think that's a balance we need to also kind of respect. So thank you very much, Judge. Now I would request Commissioner Evelyn Olwade to ask her questions.
Thank you very much, Chair. Good afternoon, Judge.
Good afternoon.
My first question deals with the death penalty. Death penalty. The death penalty has been dealt with and discussed in our apex courts in several perspectives. 3 cases come to mind. We have the Ngotho Mutiso versus Republic case, Mwaura versus Republic case, then the famous Muruatet, which you already spoke about. Now, Judge, I just need you to differentiate between the holdings in these 3 cases concerning the death penalty, and tell me your views, your personal views concerning those holdings.
I will try to admit that other than Muruatetu case, given my area of focus, right now in the judiciary, I have not interacted directly with those 2 other decisions, but if you were to give me the ratio in those decisions, then I'll be able to give you a very good answer on what I think.
In the Ngotho Mutiso case, the ratio concerns the constitutionality of the mandatory nature of the death sentence, and the finding was that the Constitution does not restrict discretion on the subject of the death sentence, specifically in respect to murder trials. In the Mwaura case, the question was whether the death sentence was unconstitutional by virtue of it being or offending against the freedom from torture, inhuman, and cruel punishments. And the Muruatetu, of course, you said you know.
Yeah. First of all, I really appreciate the Supreme Court decision and direction in allowing judicial officers to have discretion based on the facts of each case on issue of death sentence. Of course, the Supreme Court left that death sentence as a lawful remedy because I believe that is still our constitutional edict that death penalty was not still a lawful sentence in our constitution. I think central to all that, and to which is applicable in my own view to any registration which hinders the discretion of a judicial officer by giving a minimum sentences, is that we should have none, because the function of a judicial officer is to balance each case on its own facts and merit, so that we do not see, for example, a lot of injustice, which I think we've read about so much, about the young boys languishing in the cells all over for longer times than they would have, and the judges been given discretion to consider their specific circumstances in each case. So that is my view, without going into the details of those cases, because I haven't interacted much with them.
And what about the death penalty itself? That is about the discretion. What about the death penalty?
Sorry, I've just said that our constitution did not outlaw that, and I believe that is why the Supreme Court did not go that way. And but the law evolves all the time, depending on the context of each nation. And I'm sure this is not the last we've seen of that in our development of law and justice in our country.
Okay, thank you, Judge. Under what circumstances can a public officer maintain an account outside Kenya?
You have to be specifically be allowed to do so by a parliament registration. If there is no enactment which allows you to do that, then I think you're prohibited by the Constitution itself to do that as a state officer.
Do we have an enactment that allows as we speak?
I'm not aware of one.
You're not aware of it?
I'm not aware of it.
We actually do. The Leadership and Integrity Act. It gives the circumstances under which
yes, I have seen.
You can maintain
an account. I have seen that.
Okay,
yes.
Thank you, Judge.
Yeah.
Can a Chief Justice hold dual citizenship?
A state officer should not.
A Chief Justice?
As a person holding a state office, I believe, should not have dual citizenship. A state officer.
I'm specific to a Chief Justice.
No.
Not at all?
Okay, judges, I know, can have dual citizenship. I think also maybe the Chief Justice, I must admit, I'm not sure, but I think judges may have dual citizenship in terms of the law.
The Chief Justice is a judge, my lord.
I would want to reflect on that, on the responsibility of a Chief Justice, but I think as a judge, then he should have, because judges may do that. Yeah.
Okay, thank you, Judge. I must admit I was getting quite excited when you are giving your exposition on the issues that plague especially members in this institution, in the lower cadres. As you said, you lifted from the employee or staff satisfaction survey. You hinted at what you propose to do concerning some of those issues, one being discipline, which you said you are looking to developing a framework that will help this, the process to be fair and just, which basically to me, in my ear, sounded like a complaints handling mechanism or policy. And then you also talked about promotion. Promotion is also an issue, especially for judicial officers. Because you know, we all, I think about 95% of judicial officers aspire to ascend to the superior courts. The superior courts are like canon for them. But before they get to that canon, there are several red seas they have to cross in the form of promotions. Now the challenge here is there is no indication when this red sea will open. And that is the problem, like you aptly put it, with our promotions. So I want to hear from you, Judge, and for your prospective subjects, if you become Chief Justice, for their benefit, what would you do, or what do you propose to do to arrest or address this problem?
Of promotion?
Yes, my lord, it actually affects not only the magistracies and the cadres, even the judicial staff. It's a very sore issue.
I am very, very aware of it. Not now, just for purposes of this interview, but I've interacted with that as a principal judge immediately as I was serving. I interact with this because, as I said, I'm a very interactive person, so I speak to judicial officers at every level, freely and openly, and so I am aware. For example, what happened to those who had applied last time round to be promoted from magistracy to...
Actually, Judge, I'm talking about promotion within the ranks of the magistracy, the cadres, and judicial staff.
Yes, I'll come back to that, but I wanted also to tell you that I'm aware that even as a chief magistrate and tried to become judges, I was aware, and because I interacted with them, that it appeared as if there was a minimum age, number of years you must have served to be even shortlisted, although it is not part of an open framework. And I believe so much in transparency and based on documented and developed through interactive processes, so that if we are having problems of career progression from the first level of magistrates to the next one and to the next one, and same with the other cadre in the not in the judicial service. What we need, I know we have a big human resource manual. I'm also, if you look at my CV, I also trained in the South African Institute of Management on matters human resource. So I'm very aware of difficulties of implementing policy which is hidden in big books and not translated into small, workable documents accessible to everybody, so that they know this is a criteria from moving from a resident magistrate to the principal magistrate. And these are the considerations, and they must be taken into account. And this is becomes a policy document that must be developed as a working document for implementation purposes. That is the only way you will ensure that there is fairness in the movement of judicial officers at every level. It's transparency in and developing accountable small frameworks extracted from the big book, so that any JSE dealing with promotions is alive to the fact that everybody knows what the criteria is, and that they have been commanded by, or they have commanded themselves because of course the document eventually will belong to JSE to follow this line, and sometimes also that also, once you have transparency, you deal also with perception. There's a reality and this perception, but in this case I know there's a lot of reality, but transparency brings, also kills perception and acceptance of whatever decision JSE makes in promotions. So that's the key.
Thank you very much, Judge, for that response. My next question I've lifted from what you said earlier. You said a court order has to be obeyed, whether the person agrees with it or not, because to do otherwise would lead to anarchy. Now I want to ask you, if a party is vehemently opposed to an order that has been served on him because he totally doesn't agree with that order, what is his remedy?
He must implement it and seek redress.
In what way, my lord?
He will make an application to have the order set aside. If he does so immediately, then the matter will be reconsidered, because there's always room for review of orders of court. But if you do not move an application for review, or you don't file an appeal, then you must obey the court order. And even if you move for review, or you file an appeal, and you apply for a stay pending the hearing, and you don't get it from the court, you must obey that order.
Thank you very much, Judge. Now, another concern I want to raise with you concerns the membership in your court and the other specialized court. There is a general feeling that they are not put at par with the members of the High Court. I'm talking about the courts of equal status. And when it comes to nomination, which is almost more or less the same thing as promotion for magistrates, to the Court of Appeal, they feel like they're disadvantaged. What will you do to address those concerns if you become Chief Justice?
Thank you very much for reminding me of that. I should have even talked about it earlier. And those of us who sat with me at the JLAC know that I was very passionate about that, and I actually brought concept papers. I was asked to, because of my persistence, that let there be equality, because the Constitution tells us we have established courts of equal status, and therefore let us treat them equally in all matters across the board. And I remember during the last elections in 2017, and JLAC was faced with the issue of swearing of governors, and the view there was that an ELC and an ELRC judge is not qualified to swear a governor. And when I persisted and I asked to be shown which part of the Constitution says that, which law outlaws us from doing that, of course I lost by vote, having been told to present a paper on it, and to because of my persistence in there, that we are not being treated equally. Having sworn governors in 2013, myself, I swore the governor of Marsabit and Justice Mutunga. I went to swear that time the entire assembly, the speaker and everybody else, plus the governor. And then all of a sudden we were not qualified to swear judges. Then I also presented concept paper there about judges of ELC, with the support of Okongo, the PJ for ELC, being appointed as presiding judges. I think it's a matter I followed up persistently, and I was not successful, because up to now, indeed, no ELC judge or ELC judge is a presiding judge. And we witnessed also judges who had earlier on from ELC elevated to presiding judge being demoted, and judges who had just been appointed being elevated to be their bosses at those respective stations. We saw that happen, and you can only talk because you're in an advisory. While I was the principal judge, we are there to advise the Chief Justice, and I did so passionately that that has not borne fruit. But in one way, it did bear fruit. SRC then gazetted allowances for presiding judges, which include ELC and ELRC judges. Again, after that happened from SRC, I took up the matter again with the current principal judge of my court, and especially in our specific colloquial, annual conference with the Chief Justice, and we have been not successful to date. It's an area of dissatisfaction and a feeling of unequal treatment, I must say. Thank you for reminding me. And it's an area I would want to tackle with JSC as soon as I'm Chief Justice, if that be the case.
Thank you, Judge. Now, you are aware that after receiving applications from all the candidates, JSC had to take them through a vetting process. We sought information from members of the public out there, and we got information. We got complaints from various quarters. In keeping with what the chair has just told you, we got quite a bit in respect to you. Some of them touching on your decisional independence. We shared them with you, you responded. We have your response, we are going to consider them. But there's one particular one I want to raise with you, Judge, without necessarily mentioning the parties, but I'm sure it's a matter that was brought to your attention because I have seen your response. In this particular matter, the complainant was engaged in a legal tussle with his employer. And the long and short of his complaint was that at some point, he was brought before a board on disciplinary hearing, I suppose, on accusations which in his view were based on vendetta from his employer. The matter was heard. The board absolved him. Subsequent to that, the employer was not happy, and the employer changed the membership of that board, called him for a second hearing, which, of course, he refused to subject himself to, because in his view, he had already been absolved the first time. So, of course, they were engaged in a legal tussle before your court, and at some point, not necessarily handled by you from the beginning, but at some point, the complainant came before you seeking orders to suspend the order terminating his services and his pay. And you granted him those orders, ex parte. Subsequent to that, it appears at some point the employer stopped paying him, and he came back before you about 4 months or 5 months later and applied for the employer to be held in contempt. Now, instead of doing what he expected you to do, to hold his employers in contempt for disobeying your order for that period, what you did is you dismissed his application because he failed to disclose certain material facts when he came before you ex parte. Now, you are within your discretion to make that decision, but I'll tell you why this concerned me a bit. We already agree that if a party is aggrieved with a court order, it's upon him to approach the courts for necessary action and to do that promptly. It is not upon a party to decide that I agree with this order or this order is unfounded and I will not obey it. From the narration of events, I also read the judgment that you made. It seems to me that the employer in this particular case, between the period you made the order ex parte to the point the complainant applied for him to be held in contempt, he was in contempt. But in your decision, you focused only on the failure of the complainant to disclose material facts, but you said absolutely nothing about the conduct of the employer in disobeying your order, which was actually the subject of the application, in disobeying your order for the entire period until the complainant came before you. This is a concern because we are all aware it's in the public domain that disobedience of court orders is a very sore issue in the administration of justice. And the concern is, as Chief Justice, should we have concerns that you may not be up to the task when it comes to enforcement of court orders?
I think I remember that one, and I appreciate, and I responded to it in writing. The issue there is what was the nature of non-disclosure to me. I remember as I was handling that matter, is during COVID period. I'm operating from home in Nairobi. They are in Kisumu. And so, when I gave the ex parte judgment, ex parte orders, it's on a basis of an online application. I don't have the file in my house. And there goes the need for an applicant in those circumstances to give me all the circumstances of the case before I issue the order. And what was the nature of that information? That the same matter was before Justice Morino Nyango, who had considered it and issued a ruling on it. So when the matter came for an inter-parties hearing, that was disclosed to me, and actually an opportunity to see the ruling of my sister judge, which if it had been disclosed to me, I would never have issued that injunction. That is why I dismissed that application on the basis of non-disclosure. That was such a material non-disclosure that my decision was in direct conflict with a ruling already done by my sister judge. And therefore, I exercised my decision-making reasonably after considering the circumstances. And the kind of non-disclosure which was not made to me.
My Lord, this non-disclosure you discovered in the application for contempt by the complainant.
Yes.
You were not moved by the employer. Is that correct?
No. If you look at my ruling, I consider the submissions by the employer. They're the ones who disclose this to me.
In the application for content?
Yes.
Thank you, my lord.
Yes.
Okay, moving on to the application documents that you filed. I don't know if you have your files with you, your papers with you, the applications that you filed.
The application.
If you look at the advertisement that was put in the papers, the applicants were required to download Form 2, JSC 2A for public officers or JSC 2 for other applicants. This is in keeping with the statutory provisions in the first schedule, Regulation 4, that requires you to fill a prescribed form in making your application. Did you fill that form, my lord?
Yes, I did. This is a form I filled. I downloaded and filled in the...
My lord, I saw what you downloaded. It is not from JSC 2A. That is the online application. It is not the prescribed form. If you look at the advertisement, I'm sure you have a copy of it in your bundle of documents.
Yes,
the advertisement required you to fill that online application and amongst other documents, download Form 2A, JSC 2A, fill it and upload it along with your application, the online application, as well as submit one hard copy of Form JSC 2A, which form is supposed to be filled in your own handwriting. You did not comply with that, my lord.
The form I had allowed me to type in that part. And so this is a form I brought, and where there was space, there is space for typing, I did my typing, and I believed, and I said that I filled the correct form. If indeed this particular form is not the correct one, I do not know until this point, but I believe this one, the form I downloaded and filled, presented me with opportunities to deal with the application appropriately, including filling the part which was supposed to be done about my own information, which I duly typed.
Okay, my lord, if you look at the form you submitted, the way it is, because that is how it has been presented to the commission, in Form JSC 2A, or even Form 2, at the end of it, there's a declaration where the applicant is attesting to the truthfulness of all the information he has given in his own hand in Form 2, JSC 2A.
Yes.
Do you have that in your form?
Yes, I have, and I duly signed.
Is there a declaration on that form?
Yes, at the last page, and there's a signature in PDF.
The one I have, my lord, sorry, the one I have does not have that declaration. Maybe we'll get to look at the copy that you have.
It is there. Maybe there's a...
Could you read the declaration, my lord? The declaration you have in that form.
Oh, the last part says final declaration, and then the declaration date, which I put, and the signature in PDF. That's the last.
Just read the declaration, my lord.
It would appear that
there's none.
This is just in the printing, but it was there.
That's my point exactly, my lord.
It's just in the printing, but the declaration is there, duly signed and filled by myself, and dated the 8th of February 2021.
Okay, moving on to the next issue. Did you apply for clearance from the EACC?
Yes, I
Ethics
did.
and Anti-Corruption Commission?
Yes, I did, and I have presented the originals today.
Okay, thank you. Is your wife a public servant?
She is not working thanks to COVID. She's never been a public servant.
In your wealth declaration, you are required to give a schedule of your income, your assets, and your liabilities. Why do you think we ask you to give all those details? Why not just ask you, tell us what you own? Why do we ask you to give your income, your assets, and your liabilities?
I did that. It's a part for the income, all those three.
My Lord, I'm not asking what you did. I'm just asking you why, the rationale, why we are asking for those three components, not just for you to declare your wealth and tell us I own blah, 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 blah.
It's an issue of integrity.
Yes. Why?
Yes. It's in terms of the Constitution and the code of conduct that we feel, and we've been feeling those forms. It's not the first time we are doing that, and that is why we have filled for the past many years.
Yes, my Lord. What do you think we do with that information? Your income, your assets, your liabilities. Clearly stated in different paragraphs. What do we do with that information?
I'm not sure what you do with it, but it's supposed to reflect my correct status of income and assets.
Okay, let me ask you this, my Lord. If in your schedule of assets, because we fill these forms periodically, right? In your schedule of assets, we see a property that is worth as an amount X, for example.
Yeah.
There is no corresponding income of amount X, and there's no corresponding liability in terms of a loan of amount X. What are we supposed to make of that?
It reflects value of the, you have to look at when the property was acquired, because I don't believe there's any property there in my declaration which was acquired yesterday. Most of them were acquired even before I became a judge, and during only one or two which was acquired when I was a judge. What changes is the value, the market value of the property.
I'm not talking about the market value. I'm
Because
talking about...
if you see a property worth this amount of money, and in the previous declaration it was this amount of money, it reflects, because we are giving estimates, it reflects the market value of that property at that particular point in time, and development which has happened in that land. Using my income, I am developing my properties, which I acquired before I became a judge, and they appreciate in value all the time. And what is reflected there is my estimated value of my properties in terms of the market rates.
What if it's a new property, my Lord?
There's no new property.
I'm not asking about your case.
Yes.
What if it's a new property? Should that be a cause for concern?
If it is a new property, yes, there will be a cause of concern which does not apply to me. I do not have any new property because most of my assets there were acquired mainly from my work outside the judiciary, and the assets acquired when I am a member of the judiciary, acquired through the mortgage, judiciary mortgage, okay, and
if I may ask, my Lord, which property was acquired through the judiciary mortgage?
That is my home in Lavington. That was acquired through judiciary mortgage, which I have also reflected that the amount of loan outstanding.
So you stand by your word that there is no new property in your declaration?
For the period covered, the
Yes.
period of 3 years?
The last 3 declarations.
I have disposed of, if you look at them, there were properties which were there, and they're no longer there because they have been disposed of. And there is only one piece of land which was acquired, but I have also disposed other properties. If you look at carefully, I have you will see that properties which were there at this time, they are no longer there, and there's, I think, only one new property, just one. But the values, the change in values, are just a matter of market rate, not because the properties have been there.
So you say you've acquired some property out of disposing others?
Yes, you look, yes. And
is that reflected in your declaration?
I believe you have, when you look at my statements, bank statements, which are from 2017, you will be able to see disposal of property. Okay?
Is that reflected in your wealth declaration?
It is in the statements. In the declaration, you will see.
My Lord, what I would expect is this. Maybe I can just break it down for you so that you understand my concern.
Yes.
What I would expect is this. If I have 3 properties, property A, B, and C, I dispose of B and C and subsequently acquire X. In my last declaration, I had A, B, and C. What I would expect is, in my subsequent declaration, B and C would not appear, but there would be income showing on the space where I'm supposed to indicate income, that I got income from disposing property B and C, and subsequently acquired property X. And that's why I'm asking, is that reflected in your wealth declaration?
If you read that in conjunction with my bank statements, it's very well taken care of.
Okay, let's move on. Let's move on, my Lord. There's a company, I'm assuming it's a limited liability concern, called Cited. In your wealth declaration, you have mentioned it severally, but my concern is you have not disclosed what your relationship with Cited is, and if you are one of the owners, in what ratio your shares are, and what it is worth.
That company is not operation. It's there, but it's not. Since COVID, is not operational. Since 2006, it's a business by my wife, HR consultancy, which she has done since 2006, and submitted accounts to KRA, financial statements for all that period, and I have indicated that in my declaration. We don't have much space to say other than indicating our personal emoluments, and I indicated that the accounts of that company have been filed since 2006 with KRA.
What is your relationship with Cited?
Cited,
do you have shares in Cited?
Just a family. What is it called? Is it called nominal one? For that time, because you could not register with as a single director.
So it's a company owned by your wife?
By my wife, and she has consistently filed accounts, and that is why we got clearance, I believe, from KRA, because she has been compliant throughout. But now there was a small family concern.
Okay, thank you.
She's been running it herself, and now it is not operational because its area of focus could not go on due to the international, the closure of international boundaries, because our focus was outside the country. She was training and personnel mainly from without Kenya, and that's why she could no longer operate.
Okay, thank you. And are you a Sharia SACCO member?
Yes, I am, and I provided statements to that. I don't know whether you've received my bundle of statements.
I saw your bank statements.
There is also a bundle of statements from Sharia SACCO, which one?
You also did not declare indicate the dividends amongst the income that you get, the SACCO dividends.
Yes, they are all in those statements, because all along, I must say that we have been submitting these wealth declarations, not for purposes of interviews. And those forms have no space telling you indication that you're supposed to make attachments. We have never been asked to attach any document to those declarations. In fact, I'm sure almost all the candidates were surprised by the requirement that we attach bank statement, because it was not apparent at all in the advertisement. We've never done it before. All what we do the estimates of our income, and we declare our assets, and we don't attach any documents.
Actually, my lord, maybe to make it clear,
But
because
you
now
will see the attachments of my bank accounts clearly show my little contribution on a monthly basis to Sharia Sacco. They show that whatever dividends they pay match. They also show the loans I have the loan I have taken there, and they show my contributions to date. And so, for purposes of accountability and transparency, you will see everything in that statement from Sharia Sacco.
Okay, thank you, my lord, for submitting your statement. I saw your statements this morning, but I just want to make one thing clear. We did not ask for bank statements. I know this must have come from the questions that the previous candidates have been asked. What I've been asking about is declaration of your bank balances. If you have an account, you have money, that under Section 2 of the Leadership and Integrity Act, in that description, money is one of the assets that you have. So that if you have 2 million in your account, all you're required to say is that I have an account at this bank and the balance there is 2 million, because that is part of your asset, not necessarily the bank statements. And at the same time, about the forms, you're always at liberty to attach an extra form or an extra paper detailing your assets if the space there is not sufficient. Just to set the record straight, my lord. Otherwise, thank you very, very much for your patience. I'm done. All the best.
Thank you. Thank you.
Commissioners and Your Honor, this brings us to the end of this interview. And yes, Honorable DCJ.
Thank you. My lord, there is something you said that I think we should not leave hanging. And you said that the manner in which the Supreme Court has handled, you are calling them two, but the Supreme Court has actually handled 3 presidential election petitions, has left uncertainty. That's what my lord said.
Has left?
Uncertainty.
Oh, uncertainty. The two. We were focusing on two of them.
Then my lord has also expressed dissatisfaction, I think that's what I got, about the Weber case. So those are 2 concerns there. This is the question. What in law can or should be done about those judgments? Now, when I asked you the question in the beginning, I said, you give us either a critique or a criticism. I do not know what it is my lord gave us. Was it a critique or was it criticism? But whichever it was, because both are okay.
Yes.
My lord feels that we have convoluted issues rather than shown the way to go in both the election cases and in the Weber case. And so I ask, this also is a learning process, or is it not? So I ask, my lord, then what are we to do? What do we do with those judgments?
Maybe convoluted.
Within the law, not what we feel. Within the law,
yes.
What do we do? That's the first part. The second part, when my brother, the Law Society representative, was talking to you, there's something there you said, about the big picture, all right? And I want to know whether that big picture is part of our jurisprudence and how it relates to constitutional interpretation theories. Those two clarifications, my lord.
On the first one, maybe convoluted is a strong word. I did not use that. But especially on the Law Society case, its impact on the ground is very, very real. There's a lot of disaffection in the way, especially from the court users.
My lord, that I had, that
yes.
we had, and
preparing
and
to answer you.
incidentally,
yes,
we began there.
Oh, I see.
During my practice, we went to the director first before we went to any court those days. So, of course, you answer the question in the manner you best think is the way to satisfy us. But for me and my constituency, it is that critique or criticism, the judgments stand. They are the judgments of the apex court, the final court in the land here. And so I'm asking, in the law, because we can only act within the law, what are we to do?
Okay. Actually, there has been a lot of robust discussion of that amongst ourselves and the LRC court, because we also realized we are handling the issues differently, and we also got a long memorandum from the magistrates raising the concern that in the court users committee. They have a representative saying that they are totally confused. They don't know what to do, and there's a lot of disparity in how the different officers are dealing with it. And so we said, the opinion was, let the matter go slowly up to the Supreme Court to be dealt with. And in my view, I strongly I think that may not even happen, because that depends on the court users to move. But this case, we have a particular court user, the Law Society, which, with its capacity of legal minds, probably would want to engage the Supreme Court once again on that particular remedy for clarification, so that then you can also now reconsider the matter quickly and give an edict to the rest of the courts. That would be a much quicker way, but of course it depends on the court user. From where we sit at the judiciary, we can only watch as decisions are made and they come, hoping that one day they will reach you again, and which I think is not a satisfactory way of dealing with our court users. So that's one. The other one was,
my lord, it was the use of the word, the bigger picture. And so I'm asking whether that is an emerging form of jurisprudence, and whether how have we been interpreting the Constitution? Are there not enough theories on how to interpret the Constitution, and is the bigger picture part of that jurisprudence?
I do not recall myself using that particular word in that context of interpreting the Constitution, because I said very clearly that the Constitution has got commands in various articles telling us how we should interpret it and what values and principles we should use. I think that was my bottom line, but I don't think if I used the word bigger picture was in that context of interpreting the Constitution.
Thank you, my lord. As I said, it doesn't matter whether it's a critique or criticism.
When it was a critique, I think we are bound by the decisions of the Supreme Court.
Actually, that's the word I was looking
and
for.
You have seen that in some of my judgments I have submitted. I have a lot of deference to your decisions of that court, but I think
it is criticism.
A critique is good at this kind of forum.
It is criticism that would make that court grow, or any court for that matter.
Yes.
But it has to be criticism that is within some parameters, isn't it?
Yeah, within the law.
Yes. I thank you, my brother. I thank you.
Chair, just to Chair.
Yes, we need to bring this to an end, Commissioner, but go ahead.
Yeah. I mean, just arising from what the Honorable DCJ was asking, like you mentioned about that case of Weber, where a good decision, but so many other complications arising.
Yes.
You know, the big picture in that sense, that when the decision is being made,
I think so.
You as the CJ ensuring that you look beyond the decision and the implications. Same thing also with Muruateto, where good decision, but again, all the courts interpreting differently and coming up with different parameters, so causing more complications.
Yes.
So I don't know that, so big picture in that sense, are you able to expound what kind of a CJ would you be to ensure that even as you're making the decision, you're able to foresee that in the implementation, it doesn't end up causing more problems, even as you're coming up with the constitutional interpretation and principles?
Well, as I said, that as the Supreme Court, even as the Chief Justice, we are only but a college of judges, with me being the first among equals and the DCJ being the second, and we cannot just use the best of our persuasion to make sure to sensitize ourselves on the need to issue effective court orders, especially if matters are likely to affect a very big constituency like is happening now. The Supreme Court itself has addressed itself very much on the effectiveness of court orders, and in particular in Mitubel case, where they felt very strongly that the orders of the High Court were not effective and they were general and they'd set them aside. So I'm actually speaking from the mouths of the Supreme Court judges on the need to have effective final orders which are capable of implementation. So I think that is, if the big picture was in that context, then I think that was the view of the Supreme Court, especially very strongly expressed in the Mitubel case. That is what I was talking about. The need to have effective orders capable of implementation without causing hardship. Yeah.
Thank you very much, Honorable Judge. We will stop there. We want to thank you, Judge, for your, number one, applying for this job and also availing yourself. And also talking very passionately, Judge, about what you believe in, and also being very candid and very honest. We want to thank you for that. And on behalf of the commissioners, we wish you well. But before you go, do you have anything you'd want to tell the commission, Judge?
Ni vema na haki ni mshukuru sana sana kwa vile mmenitendea haki na mmeendesha hii hafla kwa njia inayofaa, kwa makini, hekima na utulivu mwingi. Kwa kufanya hivyo nafaa nimpe sifa, manake kazi yenu inapatia Kenya yetu sifa. Napatia na mnapata sifa katika ulimwengu wote na mbele ya Mwenyezi Mungu, sifa nayo inastahili mpate. Na kwa hivyo mimi nawashukuru sana, nampongeza na wahisi muendelee vile vile mpaka mtakapopata jaji mkuu atakayetumikia Kenya kulingana na katiba yetu ya Kenya. Mungu awabariki na waongoze. Asanteni sana.
Thank you very much, Your Honor. So we come to the end of this session. Your Honor will be escorted out by Honorable Anne Amadi. Thank you.
Every time I'm in front of the camera, I remember my culture.
After all, story ni yetu. Kama unadai drama origi, telenovelas na sports, get your GoTV decoder na 1 month GoTV Plus for 1,299 bob. Download my GoTV app kumanage account yako on the go, ama dial *423# to subscribe, to pay, to reconnect, to upgrade, ama to clear errors. GoTV, love it. 92.9. Hii ni KBC Radio Taifa.
Kila kitu maishani kina sauti yaleta furaha. Radio. Sauti ya elimisha, yahimiza, yatuleta pamoja. Sauti ya Kenya.
Radio Taifa.
Hello, Young Initiative Africa. My name is Asha Sampath. Welcome to your weekly magazine featuring Africa and the move through smart innovations and initiatives that work. Let's get on with the show with our top stories today. We met Oluwasegun Kosemani. He is the chairman of Nigerian cryptocurrency fintech BotMeCash and has not hesitated for a moment to jump into the arena of electronic money. These payment solutions are literally blazing in Nigeria, one of the continent's leading countries for this new form of currency. He's our guest of the week.
Bitcoin has so much value, like your fiat. It is used for real-world cases, buying and selling, exchange, hedging of funds, etc.
Should we trust cryptocurrencies? Nigerian authorities are wary, much to the dismay of users in the country.
I think the truth we need to realize is that, look, cryptocurrency are here to stay, right? There are debates here and there, but what we are seeing lately is that there are a lot of institutional acceptance.
Finally, a spotlight on the cobra, a feared snake that highly sought after for its venom with medicinal properties.
Je travaille avec les laboratoires de reptiles depuis 25 ans. Je leur fournis depuis ce temps-là les différents types de venins que je récolte auprès de dizaines de reptiles ou d'arachnides très différents. Les scorpions, les vipères ou les cobras.
As I mentioned in the highlights, Nigeria has become in recent years one of the countries and the continent at the forefront of cryptocurrency transactions, occupying the third place in the lead among the nations that use these alternative forms of payment the most, behind the United States and Russia. The country recorded cryptocurrency transactions of more than $400 million in 2020. A decommissioning of the classic monetary system and an anonymity of payments that displeased the Nigerian authorities, hence the imposition of restrictive measures in February. Our reporter Yuga Yuana has been following these developments very closely. He has the details. For years, cryptocurrency trading has grown in Nigeria, one of Africa's largest economies. Recently, Nigeria's Apex Bank, the Central Bank of Nigeria, notified deposit money banks, non-financial institutions and other financial institutions against doing business in crypto and other digital assets. On February 5, 2021, it issued a stern warning and reminded local financial institutions against having any transactions in crypto or facilitating payments for crypto exchanges. It also instructed the financial institutions to immediately close the accounts of such persons or entities transacting in or operating cryptocurrency exchanges.
I got some profits, but recently the policy came up, and the CBN policy, and to be honest with you, some of us still don't understand. At first it was as if it was a ban on crypto, but then later on there was like another story about it. So some of us still don't understand what the policy is about. However, the moment the policy came out, that very day, I had to pull out some of my investments, immediately, and I pulled out some of my investment from Bitcoin, only for me to find out that Bitcoin increased again recently, and I just felt so bad,
Treasure Eruro is one among millions of Nigerians who use cryptocurrencies. The West Africa economic powerhouse is now ranking as the third top country for trading volumes. With $100 spent on each trade on average, there's no doubt Nigerians find cryptocurrencies attractive.
Cryptocurrency for me is just a source of side income, more like alternate income for me. I do a 9 to 5, but it's something I do on time. It doesn't interrupt my work. I got into it recently, not too long, and I think I did it because that was like what was trending. So my friends were going into it. They kept talking about Bitcoin, Ethereum and all this kind of stuff. And I thought, you know what, I don't want to have to be left out of this. So I joined in, and I've made some cash from it.
The success of this alternative form of payment is causing unease among African monetary authorities, and Nigeria is no exception.
The CBN needs to review this policy, because in 2020 alone, the transaction volume on Bitcoin alone ran into billions of naira from Nigeria alone. We're not even talking about other African countries. And the CBN is saying that banks should no longer back cryptocurrency. But the truth is that every single transaction on the Bitcoin network, banks get transaction fee. So in other words, the banks are making more money, and of course more employment opportunities are coming for young Nigerians that here they have nothing to do. We're looking at blockchain technology here, decentralized technology. What this means is that a new technology is on board, and young Nigerians are getting employed. Young Nigerians are learning new programming languages. Cryptocurrency has offered a lot of opportunities for young people. So what the CBN needs to do is to sit down with stakeholders again and review this policy again, because it benefits both the CBN, it benefits the banks, and it benefits the young people.
It was reported that each month $65 million worth of cryptocurrency transactions are carried out in local crypto exchange platforms in Nigeria. With the soaring figures in financial returns, will the Nigerian Central Bank reconsider its stance?
I think the truth we need to realize is that, look, cryptocurrency are here to stay, right? There are debates here and there, but what we are seeing lately is that there are a lot of institutional sectors. So you see Elon Musk investing significantly in that. So the question is, how do we ensure that innovation is not lost in Nigeria? And we see central banks all over the world adopting cryptocurrency, what they call central bank digital currencies, right? And I think what we need to begin to think about in Nigeria is that how do we ensure, right, we take the benefit of cryptocurrency and deal with the potential negative side, which could also be investment loss, because if you see cryptocurrency, in a day you can have a fluctuation about 10%. So an investor that does not have adequate knowledge can lose quite a lot of money. But nevertheless, we need to find a way to embrace it, and we know several central banks in the world have adopted testing central bank digital currencies. I think that's one of the things our central bank needs to begin to adopt.
With a vibrant youthful population, an innovative tech ecosystem, an unstable currency, a high remittance activity and soaring profits for investors, the cloud of uncertainty hovering around the Bitcoin market may not linger for long, owing to the fact that the global economy has embraced cryptocurrencies. Nigeria, one of the largest economies in Africa, will not want to be left behind. And indeed, our guest of the week knows a lot about this currency which is not liquid. He has just founded Destiny Cash, a platform on which you can exchange virtual money but also pay your bills. What more to compete with a traditional bank? But can we really trust these new means of payments? He's convinced about it, as he shared with our journalist from Lagos, Sharafa Abagin.
Oluwasegun Kozamani, hello. You just launched Botany Cash. What does this platform have to offer?
Oh, thank you very much. Like you like to say, Botany Cash is a cryptocurrency, digital assets, and payment platform. We buy and sell Bitcoin, make it easy for people to buy and sell Bitcoin, of course other altcoins. We convert your overloaded or unused airtime to cash. Gift cards we also buy. You can pay your bills now on Botany Cash. You can also buy airtime and do so many transactions that you usually do with your traditional bank. But of course, we buy and sell Bitcoin, which is major. We're a cryptocurrency exchange platform, like I said. It's a way of life. So we have come to offer value for people that really, really want better financial services and, of course, financial freedom.
To remind our African viewers, what is exactly a Bitcoin? How does it work? And why does it represent a lot of money at the current rate?
Oh, beautiful. For the layman, Bitcoin is basically a virtual currency that relies on the blockchain technology for peer-to-peer instant transaction. Bitcoin has so much value, like your fiat. It is used for real-world cases, buying and selling, exchange, hedging of funds, etc. It has so much value because, like I said, it functions in many ways for real-world use cases. The demand and supply of BTC, as it can be abbreviated, has actually made it very scarce and valuable in terms of need. The FOMO, fear of missing out, make people want to really, really buy quick, even when it dips. So I believe that the fact that you can use Bitcoin for cross-border remittance, the fact that you can pay the man at the bus stop selling suya with BTC and you choose to accept either in fiat or in Bitcoin, has made Bitcoin even more valuable than our fiat. And of course, you can spend Bitcoin anywhere in the world. It's accepted anywhere in the world. It's the sixth currency that is mostly accepted worldwide. So I think it has more value than major fiat, of course, than Naira of the country that I am from, Nigeria. So Bitcoin is the currency of now and the future.
But we must reckon that Africans sometimes don't even trust their own banking system. Why would they trust a crypto payment company?
The governments in Africa have really not done well enough for their citizens to trust them across many ramifications, across many industries. But then, Bitcoin relies on the blockchain decentralized technology. We are more than a bank. I think the security behind the data mining and ledger structure of blockchain makes it, dependable and reliable than your regular software codes that can be breached. So I want to let you know that Bitcoin is mined in blocks, and to be sincere, I haven't really heard of one person that has successfully broken the security behind the blockchain technology. So the fact that you can make seamless peer-to-peer anonymous transaction where necessary makes it even more secure. In the banks, everybody sees your money when it moves. Almost everybody that works in a bank can see your money when it moves. And whatever money can be seen, of course, can be followed. But when you do transaction with a Bitcoin wallet address, it's practically 100% anonymous. And that way, you are very, very secure.
What about security? Is it safe? And how do you deal with money laundering risks?
Oh yes, on Botany Cash, the security is about 500%. Our KYC measures is top-notch. We ensure that we collate appropriate data of our users from your name to your bank information to your address. And of course we use BVN, that's your bank verification number. We tie that to our technology. Our algorithms are written in such a way that we can trace many transactions. Of course, not necessarily the wallet address transactions that move from one wallet to another. You know, Bitcoin is naturally anonymous, but then we can identify where money is coming from and where it's going to, if we really, really want to help in some special cases. Our compliance methods are well articulated. We do our due diligence rightly, and our work environment is also very safe. We save people's information in cloud, and also we have on-prem and cloud data storage. We also do all that is necessary. Password, when you sign up, you have PIN for your transaction, 4-digit PIN. And of course, 2FA, that's the two-factor authentication that helps you protect your account in general. So it's very difficult if you haven't compromised your credential to steal money or lose anything at all on Botany Cash. And don't forget, we are a decentralized finance technology platform. We are more than a bank, we are secure.
Welcome back to the second part of our show. It's considered in some African cultures as a sacred animal, symbol of the magical and the spiritual. Well, it's the cobra, one of the most dangerous snakes on the planet. In Egypt, many are primarily interested in the medicinal potential of products derived from its venom. But to extract it, you must first capture it. Our reporter met with a snake and scorpion hunter to understand how he does it. Take a look.
Nasser Toba lives in Abu Rawak, a village close to the Giza pyramids. At the age of 52, he is one of Egypt's most famous snake hunters. Over the past 25 years, he has become the principal supplier of snake venom for Cairo's laboratories. The Toba family have been hunting snakes and scorpions for generations. They are the sole suppliers of snake venom in Cairo.
I've been working with reptile laboratories for 25 years. I supply them with various types of venom that I get from dozens of different reptiles and arachnids, scorpions, vipers and cobras. They're well known in Egypt.
3 times a week, our hunter delivers his catch of serpents and scorpions to this Cairo laboratory. His motto, whatever the animal, so long as we get the poison. The laboratory and researchers at Serum Egypt have now built up a worldwide reputation.
The Cairo laboratory is one of the world's best known in the field of biological research and the use of venoms. Egypt's foremost researchers and biologists specialized in venom research are here.
The venom is not just used to make serums. It is also a component in numerous medicines used to treat attacks of apoplexy and heart attacks. In these premises, the researchers are transforming the venom and putting it in flasks for use in the pharmaceutical industry.
يعني مثلا زي الحي القرع أو السيراسيس فايبر.
The amounts of venom gathered from reptiles and arachnids are minute.
الكمية المجمعة بتبقى قليلة قوي على وجه العموم.
As a result, they're very expensive. The price can double depending on the quality of the venom and the type of reptile it comes from.
لكن هو ممكن يوصل ل 20,000 ممكن يوصل ل 50 ممكن يعني حسب نوع السيراسيس فايبر نفسها.
Despite the sheer amount of reptiles in Egypt, the trade in venom and its export is very small scale, at less than $250,000 a year. Annual exports of snakes to the Gulf nations, the United States and Europe for the pharmaceutical industry are worth just $6.3 million. For want of an effective processing industry, the Egyptians may be passing up a golden opportunity to make added value earnings. Scientists have just developed a painkiller derived from the venom of the royal cobra. It is reported to be several thousand times more powerful than morphine. Even more promising is the news that the venom may also yield a new anti-cancer drug. The Nasa Toba snakes are full of surprises.
Let's get back to Oluwasegun Kosemani for the final part of our interview this week. He tells us about his entrepreneurial journey and how the COVID-19 pandemic has actually given a boost to his projects.
Let's talk about your first career move. You were not educated in finance or coding at all, but you were in TV. What have you learned in this field?
Oh, yes. Actually, I wanted to be a musician when I was growing up, so I love entertainment so much. I had the opportunity to work in various media houses. To be precise, I was the brand manager of Nigeria Television, owned by Virtual Media Network for many years. It's still a 24 hours music and lifestyle channel. This really helped me to work with a lot of people. As someone at the leadership terms of affairs, I was able to learn how to operate with people, and I know that people build businesses. When you build your people, they will help you build your business. And after all of that, I moved to the presidency. I did communication strategy for the Presidential Jobs Board under the Secretariat of the Special Advisor to the then President Goodluck Jonathan on job creation. I learned so much about creating wealth and creating opportunities for people. But because I love to add value to human lives, all of this, my experience, which I just mentioned a few, really triggered my quest for breaking out of the norm, for doing stuff that will make my life better and the life of the people of my environment better. And in this case, my environment is Nigeria and Africa. I see that Nigerians in diaspora work so hard and they remit money back home. And having built fintech products for some financial institution, I merged the knowledge from the entertainment and creative sector to while we were building for the banks to my experience in diaspora, and I said, you know what, I must create with my team, my magic team, a unique product that can really, really help people be financially free, create wealth, make more money, and do stuff that will make them decentralized, stuff that will make their finance be off the radar from the government policies, unfriendly restrictions, etc., etc.
And this is when you ventured into artificial intelligence. How did that go?
Oh, wow. AI, artificial intelligence, very interesting technology and industry. Like I said, I've always loved to add value to human lives. And after building a cross-border remittance product called the Diaspora Banking Application, which we own the trademark for, United Bank of Africa. Shout out to the current group GMD, Kennedy Zoka, who gave us the opportunity to explore as soon as we came back from New York with the idea. And we built with the bank. We really learned a lot from the experts the bank had, and of course our magic tech team. We wanted to do something extraordinary, and we knew that customer service is a big problem in Nigeria. Marketing, sales generation, etc., etc. And automation was taking over the world. It was only smart for us to understand what natural language processing machine learning and the rest can bring to the messaging and communication platforms that we have available. The truth is, any business that is able to find customers where they communicate with their friends and family will successfully sell or be on top of the heart of that customer. And mostly the messaging environments like WhatsApp, Facebook, Messenger, iMessage, Twitter, and co. Can be integrated into chatbots. And you can really use that for marketing. You can use that for better customer service. You can use that to generate leads. You can even use it to book appointments. So we invented Conversa, which is a chatbot building platform. It's built for various people. I predict that by 2025, chatbots will basically be taking not over people's jobs, but enhancing people's job and taking the place of things like concierge work, receptionist work, or things that can be automated. And if your job can be automated, or you don't necessarily have to lose that job, you just have to upgrade your skill. And of course, we have built a chatbot using AI, machine learning, and natural language processing, which is NLP, to build a chatbot for Botany Cash 2, where you can quickly reach us anytime, any day, anywhere in the world. We also built for NIDCOM, Nigerian Diaspora Commission, which was really helpful for Nigerians that were trying to come back home during the COVID-19 worldwide lockdown.
You said that COVID-19 and the lockdown played a role in preparing to launch your company. How was this time for yourself and for your staff?
Wow. We all know that the pandemic was a tough one. For me and the people in my generation, it was the first time we're experiencing something of that magnitude, locking all of us in the house. At the time, we were already working on how to get our international money transfer operator license for the trademarked diaspora banking application that we were trying to build in partnership with some of our great, potential investors. But when the COVID-19 pandemic hit, it shut down all the plans that we had. Government institutions were not working, and investors pulled back. So we looked straight at blockchain. And blockchain was the game changer for us. And we said, all of these codes that we have written in the past and in years, why don't we just put them together, concatenate where necessary, and innovate with the popular fast-rising currency, Bitcoin, which is really liberating people from poverty where necessary, and can be used to hedge your funds and do so much more. And quickly, we put our heads together, intensified our research capacity. We started spending money on upgrading our technology, and my team, I ensured that my team acquired the right knowledge. For about 3-4 months, we did this, and quickly, by the 17th of June,